Please be seated. The sitting is open. La Cour se réunit ce matin pour entendre la Chine, la République islamique d'Iran, l'Irak, l'Irlande, le Japon et la Jordanie sur les questions soumises à elle par l'Assemblée générale des Nations unies relatives aux conséquences juridiques découlant des politiques et pratiques d'Israël dans le territoire palestinien occupé, y compris Jérusalem-Est. Comme je l'ai déjà mentionné, chaque délégation est priée de ne pas aller au-delà de 30 minutes allouées pour sa présentation. Ce matin, la Cour observera une brève pause après la présentation de l'Irak. I shall now give the floor to the representative of China, His Excellency Ma Jinmin. Your Excellency, you have the floor.
Mr. President, distinguished members of the Court, it is a great honor and privilege to appear before you on behalf of China. China is committed to promoting the rule of law in international relations, stands in firm support of the Court in preserving and safeguarding international peace and security, international order, fairness, and justice. Dealing with the question of Palestinians served as a litmus test for collective conscience of humanity, the wisdom of United Nations, and the authority of international law. The question of Palestinians has persisted for over a half a century, inflicting sufferings across generations. Countless Palestinians have been waiting in vain their entire lives. Yet, there remains no glimmer of hope in their efforts to restore the legitimate rights of Palestinian people. Fundamentally, the foundation of two-state solution has been continually eroding. The relevant UN resolutions have not been effectively implemented. China has consistently supported the just cause of the Palestinian people in restoring their legitimate right. Chinese President Xi Jinping has stressed on multiple occasions that China calls for comprehensive ceasefire and early solution to the question of Palestine on the basis of two-state solution through negotiation. China submitted its written statement to the Court last July. Today, I would like to further elaborate on China's view. My statement will be three parts, dealing with respectively the advisory jurisdiction of the Court, self-determination of peoples, as well as jus ad bellum and international humanitarian law. Mr. President, I will now turn to address the matter of jurisdiction. In this regard, China submits that the Court has jurisdiction over this case, and there is no compelling reason for the Court to decline to exercise its jurisdiction. China observes that some written statements submitted last July claim that there are compelling reasons for the Court to decline to render advisory opinion. Their main concerns are, first, an advisory opinion would circumvent the principle of consent. Second, the advisory opinion would undermine the established legal framework for resolving the question of Palestine of adversely impact negotiation process. China is of the view that these two arguments are not tenable. First, the subject of present request falls within competence of the General Assembly and has always been on its agenda. Therefore, the Court, by rendering advisory opinion in this case, would not circumvent the principle of consent in the settlement of bilateral dispute. The question of Palestine with origin in this mandate system on the League of Nations go beyond the scope of bilateral affairs between Palestine and Israel. It directly relates to the responsibility of the UN on international peace and security. The UN has permanent responsibility toward the question of Palestine. Second, the issuance of advisory opinion by the Court would not contradict the established legal framework or disrupt negotiations to settle the question of Palestine in accordance with international law. The Court's advisory opinion will not set up new legal framework or rules. Rather, it will find its basis in the established legal framework, including relevant Security Council resolutions and Oslo Accords, and present an interpretation of relevant legal questions. Furthermore, the advisory opinion will offer clearer legal guidance on the legal issues involved in the negotiations, thus facilitating the relaunching the negotiation process. China supports the Court in discharging its jurisdiction in accordance with the law, with focus on identifying, interpreting, and applying existing rules, upholding the purposes and principles of the UN Charter, providing legal guidance to UN in dealing with the question of Palestine, and fostering proper settlement through peace talk. Mr. President, now I will turn to the Palestinian people's right to self-determination. The Palestinian-Israeli conflict stems from Israel's prolonged occupation of Palestinian territory and Israel's long-standing oppression of the Palestinian people. The Palestinian people fight against Israeli oppression and their struggle for completing establishment of an independent state on the occupied territory are essentially just actions for restoring their legitimate rights. The right to self-determination served as precise legal foundation for their struggle. Self-determination of peoples is a fundamental principle of modern international law, enshrined in the UN Charter and collective human right under customary international law. In 1955, during the Bandung Conference, the Chinese Premier and Foreign Minister Zhou Enlai solemnly declared, I quote, full support of the principle of self-determination of the peoples and the nations, as set forth in the UN Charter, and took note of the UN resolution on the rights of peoples and the nations to self-determination, which is a prerequisite of full enjoyment of all fundamental human rights, end of quote. This declaration was fully incorporated into the final communique of Bandung Conference. Let me clarify that self-determination only applies to two scenarios, namely peoples under colonial domination or foreign occupation. Under no circumstances does the right to self-determination offer any basis for any part or group within the sovereign state to claim a so-called right to secession. International law does not recognize the existence of right to so-called remedial secession or remedial self-determination. The Palestinian people, being a group residing in territory under foreign domination, is a sui generis in international legal person as a whole. The right to self-determination of Palestinian people has been consistently reaffirmed in multiple UN resolutions and the War Advisory Opinion. This is also widely recognized by most states and international organizations. The Palestinian people enjoy the right to self-determination, which includes 5 main aspects. First, the right to preserve territorial integrity. Second, the right to maintain national unity. That is, Palestinian people in its group identity collectively enjoys and exercises the right to self-determination. Third, the right to freely determine the political status. Fourth, the right to freely pursue economic, social, cultural development. And fifth, the right to permanent sovereignty over natural wealth and resources. Every state is obliged to promote the realization of the right to self-determination and to refrain from any forcible action which deprives peoples of that right. In pursuit of the right to self-determination, these people have the right to engage in struggles, seek and receive support. On the basis of that right, Palestinian people declared the establishment of State Palestine in 1988, which has been recognized by over 130 countries. In pursuit of the right to self-determination, Palestinian people use force to resist foreign oppression and complete the establishment of an independent state. Is inalienable right, well founded in international law. Various people freed themselves from colonial rule and foreign oppression to realize independent statehood after World War II. Their practices serve as convincing evidence for the right. Numerous HAGUE resolutions recognize legitimacy of struggling by all available means by peoples under colonial domination or foreign occupation to realize the right to self-determination. For instance, the UNGA resolution 3070 of 1973, I quote, reaffirms the legitimacy of the people's struggle for liberation from colonial and foreign domination and alien subjugation by all available means, including armed struggle, end of quote. This recognition is also reflected in international conventions. For example, the Arab Convention for Suppressing of Terrorism of 1998 affirms, I quote, the right of peoples to combat foreign occupation, aggression by whatever means, including armed struggle, in order to liberate their territories and secure the right to self-determination and independence, end of quote. Armed struggle in this context is distinguished from acts of terrorism. It is grounded in the international law. This distinction is acknowledged by several international conventions. For example, Article 3 of the OAU Convention on the Prevention and Combating the Terrorism of 1999 provides that, I quote, "The struggle waged by peoples in accordance with the principle of international law for their liberation of self-determination, including armed struggle, against colonialism, occupation, aggression, and domination by foreign forces, shall not be considered as terrorist acts." It should be emphasized that the use of force by any entity or individual in the name of exercising the right to self-determination outside the context of colonial domination or foreign occupation is not legitimate. Meanwhile, during legitimate armed struggle by peoples, all parties are obliged to comply with IHL, and in particular, refrain from committing acts of terrorism in violation of IHL. Against the backdrop of the OPT, well-documented and widely recognized facts indicate that Israel's oppression policies and practices throughout its prolonged occupation of Palestinian territory have severely undermined and impeded the exercise and full realization of the Palestinian people's right to self-determination. Mr. President, now I will move on to the issue of international law relating to the occupation. In China's view, the question of OPT involves both legality of occupation per se and the legality of Israel's act during the occupation. These two aspects are governed by distinct legal frameworks. The former falls under jus ad bellum, while the latter is mainly regulated by IHL. Within the framework of jus ad bellum, the principle and exceptions are established by the UN Charter and customary international law. The principle of non-use of force is at the core of jus ad bellum. As corollary of this principle, the prohibition on acquisition of territory by force is firmly established in customary international law. Using force to occupy and maintain such occupation for the purposes of territorial acquisition or annexing an occupied territory by force in whole or in part is each illegal. They are confirmed by the Friendly Relations Declaration of 1970, the definition of aggression of 1974, and the War Advisory Opinion. Israel's occupation has been explicitly recognized as unlawful by several UN resolutions. Following Israel's occupation of the Palestinian territories in 1967, of the Security Council adopted resolutions 242 that, I quote, emphasizes the inadmissibility of the acquisition of territory by war. Similarly, multiple UNGA resolutions affirmed the illegality of Israel's occupation. In addition to the use of force by peoples under colonial domination or foreign occupation in the exercise of their right to self-determination. The UN Charter provides for two exceptions to the principle of non-use of force, namely the use of force authorized by the Security Council under Chapter 7 and the right of self-defense under Article 51. The exercise of the right to self-defense as an inherent right of states is contingent upon the occurrence of the armed attack against territorial sovereignty of a state. When can an occupying power invoke the right of self-defense? It hinges on whether the armed attack occurs in the occupied territory or within its own territory. In the occupied territory, the right of occupying power to self-defense depends on the legitimacy of the occupation per se. If occupation is unlawful, the occupying power can neither acquire territorial sovereignty nor resort to self-defense against armed attack that occurred in the occupied territory. This is rooted in the legal maxim, I quote, "No one can take advantage of his own wrong," end of quote. However, this does not rule out the possibility for the occupied power, based on temporary administration as a last resort, to take necessary forcible law enforcement measures against individuals or entity in the occupied territory. Nor does it preclude the use of force by occupying power against the combatants and military targets in accordance with use in battle. These acts must stay within the limits set by international law. Within their own territory, an occupying power is entitled to self-defense against an armed attack. However, the exercise of this right is subject to various principles, including necessity and proportionality, as reflected in customary international law. Under the framework of HAGUE, the legality of not of the occupying per se will not affect the application of HAGUE in the occupied territory. The armed conflict in which oppressed peoples struggle against colonial domination or foreign occupation in the exercise of the right to self-determination is considered as international armed conflict. Consequently, HAGUE, including the rules of belligerent occupation, is applicable to all parties involved in such conflict. It is noted that belligerent occupation is a special regime involving the temporary administration of occupied territory by occupying power, and it is governed by two principles. First, the principle of temporary administration, that is, the occupying power can exercise provisional jurisdiction over occupied territory, include limited but necessary legislative, judicial, and law enforcement power, with the obligation to maintain law and order and public life in good faith. Meanwhile, the occupying power is obliged to respect and protect civilians and property in the occupied territory under HAGUE and international human rights law. It should serve the best interest of the people of the occupied territories and free from plundering resources and property, forcible transferring or deporting inhabitants, practicing apartheid, adopting discriminatory legislation, and other related violations. Second, the principle of non-alteration of the territorial sovereignty of the occupied territory. This is corollary of principle of prohibition on the acquisition of territory by force. It underscores the non-sovereign nature of belligerent occupation. The occupation power is obliged to preserve status quo ante of the occupied territory and refrain from altering sovereignty over the occupied territory. Obviously, the rules of belligerent occupation are applicable to the OPT and should be followed by both parties to the conflict. Facts indicate that relevant Israeli policies and practices have violated IHL and international human rights law. China is of the view that temporary and non-sovereign nature of belligerent occupation means that an occupying power cannot acquire sovereignty over the territory during the belligerency. Belligerent occupation, under any circumstances, does not have the effect of the lawful annexation. The rules of acquisitive prescription in international law does not apply to belligerent occupation. 57 years have passed since Israel began its occupation of the OPT. Regardless of the duration of the occupation, the unlawful nature of the occupation and the sovereignty over the occupied territories remain unchanged. Mr. President, justice has been long delayed, but it must not be denied. The settlement of the question of Palestine requires mutual efforts from Palestine and Israel, along with the joint efforts of the international community. China encourages both parties to accommodate each other's legitimate concerns, embrace the vision of common, comprehensive, cooperative, and sustainable security, continue negotiating for peaceful settlement, and work toward two states coexisting in peace, and two peoples living side by side in harmony. Mr. President, distinguished members of the Court, that concludes China's statement. I would like to thank you for your patient attention. I also wish to thank the Registry and all the staff for your kind support. Thank you all.
I thank the delegation of China for its presentation. I invite the next participating delegation, the Islamic Republic of Iran, to address the court. I call upon His Excellency Raza Najafi to take the floor.
Bismillah ar-Rahman ar-Rahim. Mr. President, distinguished members of the court, it is indeed an honor to appear before the International Court of Justice on behalf of the Islamic Republic of Iran. Enjoying a long-standing principled position in support of the full realization of the inherent right of the Palestinian people to self-determination, the Islamic Republic of Iran follows these advisory proceedings of the court with great interest. What makes this proceeding even more prominent and focused of attention of almost every nation in the world is its concurrence with the ongoing appalling situation in Palestine, particularly the Gaza Strip. To indicate how severe and grave the situation in Gaza is, I merely refer to 3 United Nations and World Health Organization reports. First, according to the UN Secretary General, as a result of Israeli military operation, the entire population is enduring destruction at a scale and speed without parallel in recent history, and 2.2 million Palestinians there struggling to simply make it through another day without proper shelter, heating, sanitary facilities, food and drinking water. Second, according to the UN Under-Secretary General for Humanitarian Affairs, and I quote, "For children in particular, there is no food, no water, no school, nothing but the terrifying sounds of war, day in and day out, and its people are witnessing daily threat to their very existence while the world watches on." End of quote. Third, according to the WHO, the population in Gaza is facing extreme hunger with insufficient food and high level of malnutrition. Yet, the conditions in Gaza are becoming much worse every day. We remain at a turning point in the history of mankind. The opinion of this court can set the ground for saving lives of thousands of innocent women and children and contribute to the legitimate demand of the people deprived of its inherent right to self-determination for decades. It is hoped that this court will once more make history by giving a landmark advisory opinion in support of the right to self-determination of Palestinian people, which may finally help seize the illegal, prolonged occupation of Palestine. Mr. President, members of the court, in oral statement, we submit that, firstly, this court has jurisdiction to give advisory opinion requested. Secondly, there are legal consequences arising from the prolonged occupation of Palestinian territories by the Israeli occupying regime in violation of the right of Palestinian people who have never experienced the right to self-determination. And thirdly, having elaborated on the legal consequences that arise for all states and the United Nations from this status, I will reiterate the inclusive plan previously submitted by the Islamic Republic of Iran to the United Nations for realization of the right of Palestinians to self-determination. Mr. President, first we submit that the court has jurisdiction to render the advisory opinion requested by the General Assembly in Resolution 77/247 of 30 December 2022. Here we believe that the elements of Article 65(1) of the statute of the court, namely the existence of the legal question and the authorized body, it means General Assembly, are fulfilled in this case. That said, the ICJ, as the principal judicial organ of the United Nations, can assist the General Assembly to exercise its functions under the UN Charter by rendering the advisory opinion requested. Therefore, just as the court has established its jurisdiction in the advisory opinion on the legal consequences of the construction of a wall in the occupied Palestinian territory, it has jurisdiction in the present case based on the same grounds. Moreover, there is no compelling reason for declining to give an advisory opinion. Mr. President, now I turn to the first section of our reasoning regarding the merits of the matter. Here we first argue that the Israeli occupying regime has violated and continues to violate on several grounds the Palestinians' right to self-determination. The legal status of the right to self-determination is generally understood to be attributed to peoples and grounded first in the UN Charter, in several UN General Assembly resolutions, and its inclusion in Common Article 1 of the 2 International Covenants of Human Rights. As such, and I quote, "All peoples have the right freely to determine without external interference their political status and their place in the international community, and to pursue their economic, social, and cultural development, and every state has the duty to respect this right in accordance with the provisions of the Charter." End of quote. In line with the elements mentioned in the question raised for the request of the advisory opinion in the General Assembly resolution, I briefly present my arguments on a series of measures that constitute the ongoing violation by Israeli occupying regime. These are as follows: 1. Prolonged occupation; 2. Altering demographic composition in the occupied territories; 3. Altering the character and status of the holy city of Al-Quds; 4. Discriminatory measures; and 5. Violation of the right of Palestinian people to permanent sovereignty over their natural resources. First and foremost, the prolonged occupation by Israeli occupying regime confirms its intention to make it permanent, in violation of the principle of prohibition of acquisition of the territory by force. The occupation of Palestinian territories is the longest military occupation existing today. The right to self-determination of Palestinian people continues to be violated as long as this occupation ages. This ongoing violation towards Palestinians' ability to rely on a state-based rights and obligation under international law, depriving them of their inalienable right to self-determination, including the right to live in freedom, justice, and dignity. Thus, we request the Court to consider the very fact of prolongation of the occupation as an indicator of the violation of the right of Palestinians to self-determination. Mr. President, apart from prolonged occupation altering the demographic composition in the occupied territories has led to violation of Palestinians' right to self-determination. The UN Security Council has a bulk of resolution concerning the occupation of Palestinian territories, all condemning, among others, altering the demographic composition of these territories by the Israeli occupying power. Hence, it is a well-established fact that the Israeli occupying regime has grossly violated international law on an ongoing basis. Article 49 of the Fourth Geneva Convention reads, and I quote, "The occupying power shall not deport or transfer parts of its own civilian population into the territory it occupies." End of quote. Apart from that, the Court, in its opinion in the Wall case, declared that, and I quote, "The provisions prohibit not only deportation or forced transfers of population, such as those carried out during the Second World War, but also any measures taken by an occupying power in order to organize or encourage transfers of parts of its own population in the occupied territory." End of quote. Furthermore, the Court affirmed in the same case the violation of the right to self-determination based on measures taken by occupying power, which has led to a change in the demographic composition of Palestine. Mr. President, members of the Court, forcible deportation of civilian populations, widely known for one of its most infamous stances as Nakba Day, has a long history. Essentially, with the illegal formation of Israeli occupying regime in 1948 instead of former British Mandate of Palestine, the demographic composition changed significantly with the displacement of more than 700,000 Palestinians. In fact, the Israeli occupying regime was illegally established that year through a violent, arbitrary process and involved the deportation or forcible transfer of hundreds of thousands of native Palestinians from their land to create a majority Jewish colony in line with the demand of the Zionist movement. By denying the right to return of forcibly deported Palestinians to Palestine, the Israeli regime continues to deprive those Palestinians of their right to live in their homeland. The majority of Palestinians live outside Palestine, namely in Jordan, Syria, and Lebanon, with many of them remaining stateless, living in crowded refugee camps that lack basic infrastructure. Needless to say, forcible displacement of civilian population is of such a high significance that has been defined as a war crime under Article 8 of the Statute of the International Criminal Court. Mr. President, the next measure that has violated the right of self-determination of Palestinians is altering the character and status of the holy city of Al-Quds. The action taken by the Israeli occupying regime with regard to the holy city of Al-Quds have utterly disregarded the right to self-determination of the Palestinian people. Altering the character and status of Al-Quds has had significant religious and cultural implications for Palestinian people. Al-Quds al-Sharif has a remarkable religious and historical significance for Palestinians, as well as Muslims, Christians, and Jews worldwide. By altering the status quo of the city and its holy site, the Israeli occupying regime has undermined the cultural heritage and identity of the Palestinian people and has further violated their right to self-determination. The construction and expansion of the settlements, along with the violation of Palestinians' right to free movement and revocation of residency permits, have altered the demographic and cultural character of the city as well. Mr. President, members of the court, the next series of measures depriving the Palestinian people of their right to self-determination comprise of discriminatory measures targeting the basic rights of the people in the occupied territories. This has been underlined by the UN General Assembly and recorded extensively to include the killing and injury of civilians, the forced displacement of civilians, and a systematic policy of obstruction of humanitarian assistance. The Israeli occupying action, as manifested in various laws and policies, have created a system of discrimination that has negatively affected the Palestinian population. In Palestine, the occupying regime's expansionism has consolidated into apartheid through the longest occupation in modern history. It is well established that apartheid is a crime against conscience and dignity of mankind, and is further in violation of fundamental principles of international law enshrined in the UN Charter and crystallized in the international human rights law, and seriously threatens international peace and security. The Special Rapporteur on the situation of human rights in Palestine has concluded that the political system of entrenched rule in occupied Palestine, which endows one racial, national, ethnic group with substantial rights, benefits, and privileges, while intentionally subjecting another group to leave behind walls and checkpoints under a permanent military rule, satisfies the prevailing evidentiary standard for the existence of apartheid. Many laws, policies, and practices, and implemented since 1948 by Israeli occupying regime, have been aimed at fragmenting the Palestinian people and dividing them into various groups. This clearly denies the Palestinian people its right to self-determination. In tandem with the above, construction and expansion of the settlements, segregated roads, barriers, and checkpoints has created a system of apartheid, effectively isolating Palestinian communities, which manifestly violates multiple provisions of the Convention on the Elimination of All Forms of Racial Discrimination. The Court is therefore requested to opine that such policies and practices must be seized immediately as they continue to violate the right of self-determination of Palestinian people. Mr. President, members of the Court, the right to exercise permanent sovereignty over natural resources is an inevitable component of the right to self-determination. The two international covenants of human rights and a number of UN General Assembly resolutions recognize this right. The UN General Assembly has expressed grave concern over a range of practices by the Israeli occupying regime, negatively impacting Palestinians' natural resources. It has been affirmed the right of Palestinian people to permanent sovereignty over their national wealth and resources as an integral component of the right to self-determination. It has been further confirmed that the right should be used in the interest of their national development, the well-being of the Palestinian people, and as part of their right to self-determination. Yet Palestinians do not enjoy their own natural resources, which include land, fresh water, and mineral resources. Imposing restrictions by the Israeli regime on access of Palestinians to water resources, groundwater, and hydrocarbon deposits are all instances of flagrant violation of the right to self-determination. Mr. President, members of the Court, this Court has in several cases, in particular in Wall case, identified the obligation to respect the right of self-determination have an erga omnes character as one of the essential principles of contemporary international law. As a general rule, where erga omnes obligations of international law are breached, third states have mainly three obligations. Firstly, non-assistance, secondly, non-recognition, and lastly, cooperation to bring to an end such violation. In this context, an interested or third state, in accordance with the jurisprudence of the ICJ, could be defined as one which is not directly affected or injured by an internationally wrongful act, and which has yet a legal interest in the protection and compliance of the rights by the very reason of importance of the rights involved, and this very nature makes them the concern of all states. As regards the primary obligations of the third state toward prolonged occupation of Palestine, the three obligations mentioned above remained relevant in accordance with the paragraph 146 of the 2004 ICJ advisory opinion in the Wall case. In addition to the jurisprudence of ICJ, the primary triple obligations of third states towards serious breaches of erga omnes obligations find support in the practice of other United Nations organs as well. In its resolution 2334, the UN Security Council unequivocally reiterated the importance of states abstaining from recognizing occupying powers' internationally wrongful acts. The International Law Commissions, in draft Article 41.1 of its 2001 draft articles on responsibility of a state for internationally wrongful acts, along with underlying the duty of a state to not recognize as lawful a situation created by a serious breach of erga omnes rules, and not to render the aid or assistance in maintaining that situation, emphasized the duty of all states to cooperate through lawful means in a joint and coordinated effort to counteract the effects of these breaches. Mr. President, in light of above mentioned, the Court is requested to remind all states of their obligations under international law of the following. First, not to aid or assist directly or indirectly the Israeli occupying regime, enabling it to continue its prolonged occupation of Palestine and or any of its continued policies and practices that violate the right to self-determination of Palestinian people. This may include, in particular, avoiding any kind of political, military, economic or other cooperation with the Israeli regime, enabling it to continue such violations. Second, not to recognize the illegal situation resulting from prolonged occupation by the Israeli occupying regime of Palestinian territory and/or any of its continued measures that violate the right to self-determination of Palestinian people, and third, to cooperate effectively with one another in all relevant fields and forums to bring to an end any impediment resulting from the ongoing violation by the Israeli occupying regime of the right of the Palestinian people to self-determination, including from its prolonged occupation and any of its measures aimed at altering the demographic composition, character and status of the holy city of Al-Quds. Obviously, such cooperation is of utmost urgency and importance given the ongoing situation in Gaza Strip, where, according to one estimate, Israel's military is killing Palestinians at an average rate of 250 people a day, which exceeds the daily death toll of any other major conflict of recent years. In this context, I recall this Honorable Court's important order of 26 January 2024 on the request by South Africa for indication of provisional measures. The order concerns application of the Convention on the Prevention and Punishment of the Crime of Genocide, and as such, all states, in particular those providing support to Israel, are legally under the duty to prevent genocide, particularly by ceasing to provide any aid to the genocider. They are under a duty to punish perpetrators of the crime of genocide. Given the current extremely tragic conditions in Gaza Strip, the Court is respectfully requested to once again call on the occupying regime to fully comply with the order. Evidently, in practical terms, even the partial compliance of Israeli regime with only subparagraph 1 of paragraph 86 of that order is possible only through complete termination of all its military operations in the Gaza Strip. Mr. President, I would like to recall the primary responsibility of the Security Council for the maintenance of international peace and security under Article 24 of the UN Charter. I submit that the inaction or insufficient action of the Security Council, if not the main, is one of the main causes of prolonged occupation of the Palestinian territories. All the atrocities and crimes committed by the Israeli regime in the past almost 80 years are a consequence of such inaction. Even today, the Security Council is paralyzed due to the stalemate caused by a certain permanent member. Other relevant United Nations bodies have also responsibility to monitor and document human rights violations and to facilitate bringing the perpetrators to justice. This fact alone underscores how essential it is for the Court to remind the Security Council of its charter-based obligation. It must also be made clear that such an obligation cannot be fulfilled by convening meetings or issuing certain important procedural resolutions. Rather, it needs conclusive decisions under Chapter 7 of the United Nations Charter and a follow-up mechanism to ensure its full and prompt implementation by the Israeli regime. Mr. President, as our Supreme Leader said, the calamity of Gaza is the calamity of humanity and international community as a whole. Therefore, each and every state and relevant international organization has its own legal and moral responsibility to act urgently and decisively to prevent the ongoing crimes of the Israeli regime in Gaza Strip. Definitely, as the principal judicial organ of the United Nations, this Court has an important role to play. Now the world nations expect the Court to render its advisory opinion in a manner that effectively and practically consolidate the rule of law to the deterrent of the rule of power and to bring hope to Palestinians that justice will ultimately prevail. We should not leave them alone and let them down in days that they need the support and assistance of humanity the most. This is a collective legal and moral responsibility, and we must fulfill it responsibly. Finally, Mr. President, I must stress that our participation in this hearing and the content of our statement here is without prejudice to the long-standing position of the Islamic Republic of Iran regarding the question of Palestine. In view of the Islamic Republic of Iran, the only legal, practical, democratic, and just method to effectively realize the inherent right to self-determination of the Palestinian people is to hold a national referendum in Palestine. The details of this plan are contained in an official document of the United Nations issued in 2019. Lastly, this statement shall in no way imply or recognition of Israel. I thank you, Mr. President.
I thank the delegation of the Islamic Republic of Iran for its presentation. I invite the next participating delegation, Iraq, to address the court and call Mr. Haidar Shia al-Barraq to the podium.
Thank you. Mr. President, members of the court, may the peace, mercy and blessings of God be upon you. I extend to you my greetings of peace, mercy and blessing that are said, intended and hoped for by nearly 1 billion people in this world. Mr. President, members of the court, ladies and gentlemen, those who are calling for justice in every corner of the globe. It is an honor for me to represent the Republic of Iraq before the International Court of Justice today and to address your esteemed justice and humanity conscience in the tragedy of a country called Palestine and the ordeal of its people, which began in 1948 and continues to endure. As we gather in this place that captures the attention for being the fortress of international justice at an exceptional time experienced by humanity and the honorable people around the world who seek justice for the oppressed Palestinian people. Who have suffered and continue to endure ongoing injustice for 7 decades. We are confident that the decisions of your distinguished court will remain a beacon of hope and guidance for all the persecuted and oppressed worldwide. Iraq would also like to express gratitude to its friend, the State of South Africa, for presenting the case of unprecedented human rights violations committed by the occupying Israeli entity against the oppressed Palestinian people before your esteemed court. Mr. President, members of the court, we would like to bring to the attention of your distinguished court the decision of the United Nations General Assembly, Resolution 77/247, adopted during its 56th session on December 30th, 2022, under Agenda Item 47, pursuant to Article 96 of the United Nations Charter and in accordance with Article 65 of the Statutes of the International Court of Justice. The General Assembly has decided to request an advisory opinion from your esteemed court on the matters referred on the matters referred to in paragraph 18 of the aforementioned resolution. The Republic of Iraq attaches utmost importance to the supremacy of international law based on the purposes and principles of the United Nations Charter and international treaties concerning human rights and relevant international instruments, and the role of the International Court of Justice as the principal judicial organ of the United Nations. And based on the aforementioned, Iraq wants to take this opportunity to present its case and express its views regarding the pending request for an advisory opinion. Iraq believes that the Court's opinion will provide the necessary legal elements to enhance efforts aimed at restoring peace and stability in Palestine and the Middle East region. Particularly noteworthy is the fact that the Court has on previous occasions considered cases and issued opinions related to practices and violations against the rights of the Palestinian people. And specifically, I refer to the advisory opinion regarding the legal consequences arising from the construction of the wall in the occupied Palestinian territories in 2004. Mr. President, members of the Court, recalling today your distinguished court order dated 26th of January 2024 on the application of the Convention on the Prevention and Punishment of the Crime of Genocide in the Gaza Strip, South Africa versus Israeli occupying entity, we are convinced that the Court's orders under Article 41 of the Statute of the Court are of binding effect under Article 94 of the Charter of the United Nations, and we call for the respect of and compliance with these decisions under any circumstance or in any place in order to stop the systematic killing machine against the Palestinian people. We hope that the Court's commitment to justice will lead to additional decisions, affirming its dedication to ending the campaign of mass murder and preventing acts of genocide, as well as policies of harassment, blockade, and starvation against the Palestinian people. Mr. President, members of the Court, Iraq believes that the Court has the jurisdiction to issue the advisory opinion, as a request for the opinion is submitted by the United Nations General Assembly, an authorized body to seek advisory opinions under paragraph 1 of Article 96 of the United Nations Charter. The subject matter of the advisory opinion falls within the competence of the General Assembly of the United Nations. Given that Article 10 of the Charter grants the General Assembly authority regarding any questions or any matters falling within the scope of the Charter. Moreover, paragraph 2 of Article 11 specifically grants the General Assembly jurisdiction concerning any matter relating to the maintenance of international peace and security. The request for the advisory opinion is related to a legal issue, as paragraph 18 of the United Nations General Assembly Resolution 77/247, which has been adopted correctly, in procedural terms signifies we trust and hope in the justice of the court, anticipating it to not see compelling reasons for the court to use its discretion to refrain from issuing an advisory opinion. Mr. President, members of the court, international human rights law and international humanitarian law apply to the occupied Palestinian territories, and the Israeli occupying entity has the responsibility to fulfill its obligations with regard to the convention to which it has acceded, including the Convention on the Elimination of All Forms of Racial Discrimination, the International Covenant of Civil and Political Rights, the International Covenant on Economic, Social and Cultural Rights, the Convention on the Rights of the Child, the Convention on the Elimination of All Forms of Discrimination against Women, and the Convention on the Rights of Persons with Disabilities. The Israeli occupying entity is also obliged to do so on the basis of the 4 Geneva Conventions. Annual report of the Secretary General submitted to the Human Rights Council at its 34th session on February 27, 2017, pursuant to Human Rights Council Resolution 31/34 on the human rights situation in the occupied Palestinian territories, emphasizing the continuous and chronic nature of human rights violations leading to these patterns of violations. In this regard, we would like to emphasize that the Israeli occupying entity exercises regional jurisdiction over the occupied Palestinian territories as an occupying entity. Therefore, we call for and emphasize the necessity of compliance with the rules of international law and the decisions issued by your esteemed court. We specifically refer to the advisory opinion issued by your esteemed court regarding the legal consequences of the construction of the wall in the occupied Palestinian territories in the year 2004. Mr. President, members of the court, the Israeli occupying entity commit many violations and breaches of the principles of international law, and the international community has documented these violations, including those substantiated in reports by the Secretary General of the United Nations submitted to the General Assembly or the Human Rights Council. These reports focus on investigating Israeli practices that impact the human rights of the Palestinian people and other Arab inhabitants in the occupied territories, examining the human rights situation in the occupied Palestinian territories. Among these violations perpetrated by the occupying entity against humanity as a whole, and specifically against the Palestinian people, are: 1. The Israeli occupying entity adopts multiple practices that rise to the level of genocide, referring specifically to the Convention of the Prevention and Punishment of the Crime of Genocide of 1948. In particular, under Article 11 of the Convention, which defines acts classified as genocide, the killing practices that have targeted civilians in residential areas, hospitals, schools, and refugee shelters in Palestine in general, and in the Gaza Strip in particular, fall under the provisions of paragraph A, B, and C of that article. Additionally, the Fourth Geneva Convention relative to the protection of civilian persons in time of war of 1949, under Articles 146, 147, and 148, stipulates the imposition of criminal sanctions on parties to the Convention in case of non-compliance with its provisions. Two, the oppressive practices affecting the city of Al-Quds, the capital of the Palestinian state, as well as the Holy Al-Aqsa Mosque, as the occupying entity attempts to impose a demographic reality aimed at a subsequent stage, which involves emptying the city of its original inhabitants and settling extremists and racists in it. This constitutes a violation of numerous resolutions, the latest being the United Nations General Assembly decision adopted on December 21st, 2017. This decision came after a series of resolutions emphasizing the necessity of not to prejudice the demographic charter of the holy city of Al-Quds. 3, imposing a suffocating economic blockade on all industrial, agriculture, and commercial activities is evident in campaigns of land confiscation and seizure of agricultural lands from Palestinian farmers. Additionally, the destruction and sabotage of infrastructure, industrial and commercial facilities owned by the Palestinians, along with the cutting off electricity, water, and essential services, including communication and internet services, isolating the Palestinian people entirely from the world. We refer to the special report issued by the Social and Economic Commission for Western Asia, as outlined in Resolution A/77/E/2022/66, which illustrates the catastrophic economic and social repercussions resulting from the Israeli occupation and its impact on the living conditions of the Palestinian people. 4, imposing isolating measures by constructing the apartheid separation wall, depriving Palestinians of their right to move between Palestinian cities and forcing them to wait at crossing gates for long hours, sometimes extending to days, without permission to pass. Additionally, the occupying entity enforces a permit system for movement that hinders the entry of goods and medical supplies. Your esteemed court issued its legal opinion on July 9, 2004, stating the illegitimacy of that wall based on the reasons outlined in the decision. 5. Seizing Palestinian lands, establishing and expanding settlements on them, and the ongoing detention of thousands of Palestinians, including children and women, in detention centers under harsh conditions, affecting their health and jeopardizing their safety without trials according to legal principles and without providing proper care, which could lead to deadly consequences. The occupation authorities also continue to deport Bedouins from the Palestinian population from their original areas to other regions, seizing their lands. The Israeli occupying entity persists in violating the basic human rights of the Palestinian people, as well as the principle of international humanitarian law regarding the protection of the civilians during armed conflicts. Mr. President, members of the Court, based on the aforementioned, the occupying authorities are obliged to comply with the duty to respect the right of the Palestinian people to self-determination. They must immediately cease the violation of their international commitments and to respect the right of the Palestinian people to self-determination by ending all actions and measures that prevent and hinder the Palestinian people's right to self-determination. This includes the immediate termination of the occupation with all its associated actions and practices aimed at prolonging the duration of the occupation and continuing to deny the inherent rights under the rules of international law to the Palestinian people. Mr. President, members of the Court, the Republic of Iraq is deeply concerned about the humanitarian suffering inflicted on the Palestinians throughout the state of Palestine, particularly in the Gaza Strip, due to the barbaric acts committed by the occupying Israeli entity by airstrikes and rocket attacks targeting civilians. These acts constitute war crimes executed with a criminal intent and serious violations of the laws of war. The Israeli occupying entity must be held accountable. The Israeli occupying entity must be held accountable for its actions, subjecting it to international criminal liability for violating the principles and charters of human rights and the Geneva Conventions related to the human rights during armed conflicts. We avail ourselves on the occasion of our presence in this great legal edifice today in order to embody the justice we see in your esteemed court, in a strong and resolute stance to support the Palestinian people in reclaiming their violated rights and lifting the injustice about them. And lifting the injustice upon them. We call upon your esteemed court to take all measures and decisions that safeguard the lives of the Palestinian men, women, children, and elders, allowing them to enjoy a dignified and secure life where all human rights are achieved. Mr. President, members of the court, please accept our sincere thanks and appreciation to you and to your esteemed court. Thank you, Your Excellency.
I thank the delegation of Iraq for its presentation. Before I invite the next delegation to make its oral statement, the court will observe a break for 10 minutes. The sitting is suspended.
This, no.
Please be seated. The sitting is open. I now call upon the delegation of Ireland to make its oral statement before the court. I invite Mr. Rosa Fanning to the floor.
Mr. President, Madam Vice President, members of the Court, I have the honour to appear before you this morning on behalf of Ireland. These proceedings engage fundamental legal obligations owed to the international community as a whole. As a member of that community, Ireland is committed to the protection and promotion of a global order based on respect for international law. The backdrop to this hearing is a matter of profound concern to the Irish government. The attacks launched by Hamas against Israel on the 7th of October were reprehensible, and we have condemned them unequivocally. The rape and murder of civilians, destruction of civilian property, the taking of hostages, the use of human shields, and the firing of indiscriminate rockets at urban centres constitute serious violations of international humanitarian law for which those involved must be held accountable. However, international law limits the use of force in self-defence to no more than what is necessary and proportionate. Ireland's view is that these limits have been exceeded by Israel in its military response to the Hamas attack. This is manifest from the spiralling death toll, the extensive destruction of property, including homes throughout Gaza, the displacement of up to 2 million people, and the ensuing humanitarian catastrophe. Ireland has repeatedly called for a ceasefire, and we are dismayed by the implications that these latest hostilities in Gaza may have for the prospect of resolving the wider Israeli-Palestinian conflict. Members of the Court, this is a tragic conflict between two peoples, and any solution for it to endure requires each to respect the rights of the other. For that reason, Ireland has been a consistent and vocal supporter of a comprehensive two-state solution to the conflict. We lament the lack of progress made towards achieving that objective, but in the absence of any imminent prospect of a negotiated outcome, we believe that clarification now by this Court of the international law issues raised by the prolonged occupation of the Palestinian territory will assist in providing a stable foundation upon which to build a just resolution. On the threshold question of jurisdiction, Ireland's view is that the questions put to the Court are legal questions within the meaning of Article 96(1) of the Charter of the United Nations. Further, the request for an advisory opinion is, in our view, within the competence of the General Assembly. Finally, and as the Court has itself previously acknowledged, the fact that a legal question may have a political dimension does not oust the Court's jurisdiction. Moreover, while it is well established that the Court enjoys a discretionary power not to provide an advisory opinion, it should only so decline for compelling reasons, which has never happened before and, in Ireland's view, should not happen now. Several states have suggested that this request for an advisory opinion is an attempt to resolve a bilateral dispute without the consent of one of the parties to that dispute. We very much regret that Israel has chosen not to engage with the subject matter of the request. In our discussions with the Israeli government, we encouraged it to participate in these oral hearings so that the court could have the benefit of its perspective. However, in our view, the issue of the occupied Palestinian territory is directly of concern to the United Nations itself, and it goes much further than a mere bilateral dispute. As this court noted in its advisory opinion on the interpretation of peace treaties with Bulgaria, Hungary and Romania, even where a request for an advisory opinion relates to a legal question actually pending between states, its opinion is given not to the states, but to the organ requesting it, in this case, the General Assembly. It has also been suggested that this court ought not to opine because the questions are one-sided in nature. However, it is well established that the court may interpret or even reformulate a question if it is not adequately formulated, or where the question does not reflect the legal questions really in issue. Similarly, where a question is vague or ambiguous, the court may clarify it before providing its opinion. A further argument advanced by some is that the court should narrow the question to a request for advice regarding the role of the General Assembly in promoting a resolution to the conflict within the established negotiating framework. However, the court has previously rejected a similar submission, holding that it is not for the court itself to purport to decide whether or not an advisory opinion is needed by the Assembly for the performance of its functions. The General Assembly has the right to decide for itself on the usefulness of an opinion in the light of its own needs. We do not agree, therefore, that a ruling by this court would undermine the established negotiating framework. On the contrary, this court's authoritative clarification of the important legal issues raised would provide the essential foundation upon which to build a lasting, comprehensive and just resolution of the Israeli-Palestinian conflict. Mr. President, Israel has been in occupation of the Palestinian territory since 1967. Accordingly, in that territory, it is obliged to respect applicable international humanitarian law, including the law of military occupation and international human rights law. The defining feature of Israel's occupation of Palestinian territory in the West Bank, including East Jerusalem, has been continuous settlement activity. In our written statement, we have drawn on the authoritative reports of the Secretary-General and the High Commissioner for Human Rights to set out the numerous different ways in which this has occurred. But in summary, we say the following. Israel has used different means to take and exercise control for non-military purposes over as much land in the OPT as possible. Once in control, Israel has undertaken permanent construction on this land, in particular developing or encouraging the development of permanent settlements, onto which it has incentivised large numbers of its own citizens to transfer. Through its actions, Israel has fundamentally altered the demographics of the West Bank. As of 2022, almost 700,000 Israeli citizens were living in settlements in the West Bank, including in East Jerusalem. Israel has extended the application of domestic Israeli law to those living in settlements, blurring the distinction between Israel and the OPT. And Israel has transferred the exercise of authority in the OPT in certain areas from military command to civilian control, integrating administration of the territory into that of Israel. By transferring parts of its own civilian population into the OPT, Israel has violated Article 49(6) of the Fourth Geneva Convention. It has continued to do this, notwithstanding the court's confirmation of its unlawfulness in the Wall case, and despite being exhorted by both the Security Council and the General Assembly to cease this practice. Israel has also continued to unlawfully destroy and appropriate property throughout the OPT as part of its policy of encouraging and facilitating the expansion of settlements. This destruction and appropriation of property cannot reasonably be justified by military necessity. Rather, it is clear that it has been done to facilitate and indeed encourage the expansion of settlements. Such destruction and appropriation of property clearly breaches the Fourth Geneva Convention and the laws and customs of war codified by the 1907 Hague Regulations. There has also been a recent marked increase in reports of Palestinian civilians being subjected to sustained, serious violence by Israeli settlers, with little or no protection from the Israeli security forces, contrary to international humanitarian law. The security forces have been reported and recorded, not only watching this violence without intervening, but in some instances even participating in it themselves. This has escalated since the 7th of October, and the Secretary-General has warned that tensions have now reached boiling point. The Secretary-General and High Commissioner have expressed concern that this violence, particularly when considered in light of the appropriation and destruction of Palestinian property, has compelled Palestinians to leave their homes, their farms and their grazing grounds. The Secretary-General has noted that the coercive environment created by Israel could amount to forcible transfer, a grave breach of the Fourth Geneva Convention, which may amount to a war crime. Let me now turn to the question of annexation. The evident permanence of the settlements can only be explained, in Ireland's assessment, by Israel's intention of annexing the land upon which they are built. In our view, the development and expansion of settlements clearly demonstrate that Israel is and has been engaged in a process of annexation of that land for decades. The absence of any declaration of annexation or formal de jure act of incorporation over most of the West Bank is immaterial. Despite references in the current Israeli government's coalition agreements, which the Secretary-General describes as promoting a policy of application of sovereignty over the West Bank, previous history suggests that no announcement or formal act of incorporation may occur in the near future. Nevertheless, in Ireland's view, Israel is already engaged in the process of annexing Palestinian territory. It is doing so de facto through its policy of encouraging demographic change in that territory by population transfer and by the continuous development and maintenance of permanent settlements and infrastructure. Ireland is concerned that it may also be doing so de jure by increasingly extending the application of domestic Israeli law and civilian administration to the settlements in the OPT, thereby integrating them into its own territory and erasing the differences in law between Israel and the settlements. But whether de facto, de jure or both, this process of annexation is in clear breach of the prohibition in international law against the acquisition of territory by threat or use of force, fundamental principle of international law. To assert that this is not the case simply because Israel has not formally declared annexation would render the prohibition devoid of all meaning. That would permit states to acquire territory by force without legal consequence, simply by declining to adopt a formal act of annexation or incorporation. International humanitarian law does not classify a military occupation as either lawful or unlawful per se. Rather, it recognises that military occupation may occur during the course of an armed conflict, and it sets down rules to regulate the conduct of the occupying power, in particular its armed forces. Military occupation is necessarily temporary, insofar as international law prohibits the acquisition of territory by force. Occupation does not confer sovereignty. Rather, it is a temporary exception to sovereignty, and accordingly, it cannot be of indefinite duration. Prolonged occupation over an extended period of time, therefore, unavoidably raises legal questions, in particular, whether it constitutes a disguised form of annexation and/or a determined effort to deny the people of an occupied territory the exercise of their right to self-determination. In either case, the legality of the occupying power's presence in the territory inevitably arises. While it is, of course, possible that a military occupation effected by force may be undertaken in exercise of the right in international law to the use of force in self-defence, any such occupation may involve no more and may endure no longer than is necessary and proportionate to the armed attack to which it is a response. In the case of the OPT, Israel's military occupation commenced in 1967 and has continued now uninterrupted for some 57 years. It has also entailed, as I have said, extensive and continuous, permanent and deliberate settlement building. Neither the duration of the occupation nor the scale and extent of settlement activity is, in Ireland's view, justified or permitted by the law regulating the use of force in self-defence. Indeed, if the security of one people can only be achieved by the occupation over so many decades of the territory of another people, one has to wonder whether there can be any military solution to the problem that it purports to address. In our view, the only effective solution to the problem can be a political one. Mr. President, I wish to turn now to the question of self-determination. As submitted in our written statement, Ireland has concluded that by its prolonged occupation of Palestinian lands and continuous settlement activity on those lands, Israel has prevented the exercise by the Palestinian people of their right to self-determination. The principle of self-determination is a fundamental principle of international law, enshrined in the Charter of the United Nations and the two 1966 International Covenants on Civil and Political Rights and on Economic, Social and Cultural Rights. The content of that principle was elaborated in the 1970 Declaration on Friendly Relations, adopted by consensus at the General Assembly. That declaration makes clear that every state has the duty to promote, through joint and separate action, realisation of the principle of equal rights and self-determination of peoples, bearing in mind that subjection of peoples to alien subjugation, domination and exploitation constitutes a violation of that principle, as well as a denial of fundamental human rights, and is contrary to the Charter. The Declaration solemnly proclaims that every state has the duty to refrain from any forcible action which deprives peoples in the elaboration of the present principle of their right to self-determination and freedom and independence. In the wall case, the court found that the construction of the wall and its associated regime severely impeded the exercise by the Palestinian people of their right to self-determination. It therefore breached Israel's obligation to respect that right. In Ireland's view, the combination of Israel's prolonged occupation of the OPT and its escalating settlement activity has done so on a far greater scale. That escalating activity has increasingly fragmented Palestinian presence upon and restricted Palestinian use of the land and the natural resources of the Palestinian people. It threatens the viability of a future Palestinian state. The nature, scale and duration of settlement activity is such that its purpose can only be to permanently obstruct the exercise of the Palestinian people's right to self-determination. Both the prohibition of acquisition of territory by threat or use of force and the principle of self-determination are fundamental principles of international law, as are the basic rules of international humanitarian law. It is widely recognised that these fundamental principles have the character of peremptory norms of general international law, or jus cogens, from which derogation is never permitted, or, as the Court described them in its advisory opinion on the threat or use of nuclear weapons, intransgressible principles of international customary law. In turn, peremptory norms of general international law give right to obligations owed to the international community as a whole, obligations erga omnes, in relation to which all states have a legal interest, a conclusion also recently reached by the International Law Commission. Ireland has, with regret, concluded that by its prolonged occupation of Palestinian territory and the settlement activities it has conducted there for more than half a century, Israel has committed serious breaches of a number of peremptory norms of general international law and the corresponding erga omnes obligations to which they give rise, namely the basic rules of international humanitarian law, the right to self-determination of the Palestinian people, and the prohibition of acquisition of territory by force. Under the customary international law of state responsibility, where a state breaches an international obligation, it commits an internationally wrongful act. Unless its wrongfulness is otherwise precluded, that act entails the international responsibility of the state concerned, and it involves legal consequences. Where the act amounts to a serious breach of both a peremptory norm and a corresponding obligation erga omnes, this Court has concluded that it involves legal consequences for all states, namely, first, the obligation not to recognise the illegal situation resulting from the serious breach. Second, the obligation not to render aid or assistance in maintaining the situation created by the serious breach. Third, the obligation to cooperate to bring the serious breach to an end, or as the Court put it, in the specific circumstances of the wall case, to see to it that any impediment resulting from the construction of the wall to the exercise by the Palestinian people of their right to self-determination is brought to an end. In the wall case, the Court found that Israel was obliged to end the breaches of its legal obligations, including those under international humanitarian law, and its duty to respect the right of the Palestinian people to self-determination and to make reparation for the damage caused by those breaches. In the present case, the law of state responsibility likewise obliges Israel to bring to an end the serious breaches that I have outlined to the court, including by the reversing of its settlement activity and the making of reparation for the damage arising by way of restitution and compensation as appropriate. For all states, as members of the international community as a whole, to which the relevant obligations erga omnes are owed, the legal consequences of these serious breaches are, in Ireland's view, straightforward. All states are obliged to cooperate to bring these breaches to an end through lawful means, not to recognise as lawful the situation created by them, and not to render aid or assistance in maintaining that situation. In particular, states are obliged to cooperate to bring to an end Israel's serious breach of its obligation to respect the right of the Palestinian people to self-determination, or as the court found in the Wall case, to see to it that any impediment to the exercise of that right is brought to an end. This includes cooperation by states through the United Nations and, as appropriate, other international organisations, including the European Union. As regards the obligation not to recognise as lawful the situation created by these serious breaches, the Court has provided an example of how this may be achieved in its advisory opinion on the legal consequences for states of the continued presence of South Africa in Namibia. There, the Court found that the duty of non-recognition obliged states, inter alia, to abstain from entering into economic and other forms of relationship or dealings with South Africa, which may entrench its authority over this territory of Namibia. This was also the approach taken by the EU in the case of the annexation by the Russian Federation of Crimea in 2014, when it implemented a broad range of diplomatic, economic and other measures intended to preclude any implied recognition of the annexation. Those measures included a ban on imports of goods originating in the annexed territory and a prohibition against investing in it. In the present case, we say that states are obliged not to render aid or assistance in maintaining the situation created by Israel's breach of its obligation to respect the right of the Palestinian people to self-determination. The General Assembly and Security Council have, in the past, called upon all states to refrain from rendering any assistance to the maintenance of situations of denial of self-determination. In Ireland's view, these obligations require all states, as well as international organisations with external trade competence, in the case of Ireland, the European Union, to review their trading relationships with the settlements in the OPT. It requires them to take steps to prevent trade that assists in the maintenance of the situation created by the settlement activity, or that implicitly recognises or serves to entrench or legitimise Israel's settlement or annexation of that territory. Mr. President, members of the Court, Ireland remains committed to the realisation of the two-state solution endorsed by the Security Council, a safe and secure Israel and an independent, democratic, contiguous, viable and sovereign Palestinian state, living side by side in peace, within secure and recognised borders based on those of 1967, with Jerusalem as the capital of both states. This is the established framework within which it was agreed that the solution would be found, which is why recent statements by Israel's Prime Minister in which he openly rejected the two-state solution, have caused such widespread international dismay. The solution must be built on a foundation of respect for international law, but especially respect for the right to self-determination. In the circumstances, Ireland encourages this court to provide its authoritative clarification of these essential legal issues to the General Assembly as requested. May it please the court.
I thank the delegation of Ireland for its presentation. I invite the next participating delegation, Japan, to address the court, and I call upon Mr. Tomohiro Mikanagi to take the floor.
Mr. President, members of the court, it is an honor to appear before you on behalf of the government of Japan. Before addressing legal questions put to the court by the General Assembly, please allow me to briefly reiterate Japan's position on the Middle East peace process, which is stated in our written statement. Japan firmly believes that the two-state solution, where Israel and the future independent Palestinian state live side by side in peace and dignity, remains the only viable path for both peoples. Japan emphasizes that the conflict between the Israeli and Palestinian sides should be resolved not through any violent acts or unilateral action, but through negotiations and efforts to build mutual trust among the parties concerned, while respecting international law. Now, in the following oral submissions, Japan wishes to focus exclusively on the issues relating to the acquisition of territory by force, insofar as they are relevant to the questions put to the court by the General Assembly. Japan considers that the prohibition of acquisition of territory by force is an essential element of the rule of law among nations, to which Japan is profoundly attached, and of particular importance to the peace and stability in the region and international community. Japan believes that this prohibition provides an important safeguard for the international community against the return of rule by force. UN General Assembly Resolution 2625, which is commonly called Friendly Relations Declaration, states that, I quote, "No territorial acquisition resulting from the threat or use of force shall be recognized as legal," end of quote. The court clarified in the War Advisory Opinion that the illegality of the acquisition of territory by force is a corollary of the prohibition of use of force incorporated in the UN Charter. In the same vein, on 18 April 2023, G7 foreign ministers under Japanese presidency reaffirmed this prohibition. The relevant paragraph of the communique stated, I quote, "The prohibition on the acquisition of territory resulting from the threat or use of force reaffirmed in the Friendly Relations Declaration of 1970 should be observed in good faith," end of quote. Our statement today consists of three parts. First, I will address the issue of which territory the prohibition of acquisition of territory by force applies to. In the second part, Professor Dapo Wakande will speak about what constitutes acquisition by force. In the third part, Professor Wakande will examine the relationship between this prohibition and the right to self-defense. Mr. President, let me begin with the first point that Japan wishes to make. The prohibition of territorial acquisition by force does not apply only to territory of states within settled or internationally recognized borders. Even in the cases of territory where internationally recognized borders do not exist, that prohibition extends to territory that is under the peaceful administration and could also apply to uses of force across international lines of demarcation. The paragraph of the Friendly Relations Declaration relating to the principle of non-acquisition of territory by force state that, I quote, "The territory of a state shall not be the object of acquisition by another state," end of quote. It is not surprising to find the focus on attempts by states to acquire territory of another state. As an example, in October 2022, the UN General Assembly condemned attempted illegal annexation of 4 regions of Ukraine. In that situation, the prohibition of acquisition of territory by force clearly applies to those territories as they are within internationally recognized borders of Ukraine. However, Friendly Relations Declaration seems to go further than acknowledging the prohibition of acquisition of territory within the internationally recognized border of states by force. In the same paragraph, it proclaims that, I quote, "No territorial acquisition resulting from the threat or use of force shall be recognized as legal," end of quote, without reference to the territory of a state. Japan takes the position that where sovereignty over a territory is not internationally recognized, but where the territory is under peaceful administration by a state that has not itself occupied the territory by force, the prohibition of acquisition of territory by force applies also. This principle follows from the reasoning adopted in the decision of the Editorial Ethiopia Claims Commission. As this court has recognized in the War Advisory Opinion, the prohibition of territorial acquisition force follows from the prohibition of force. Therefore, the scope of the prohibition should be determined with reference to the interpretation of Article 2, Paragraph 4 of the UN Charter. Editorial Ethiopia Claims Commission found that Editorial violated Article 2, Paragraph 4 of the UN Charter by attacking and occupying in 1998 the town of Badme, which the Commission found was under peaceful administration by Ethiopia at the time. In this regard, the G7 Foreign Ministers' communique in April 2023 also stated, I quote, "We strongly oppose any unilateral attempt to change the peacefully established status of territories by force or coercion anywhere in the world," end of the quote. Furthermore, Friendly Relations Declaration states that, I quote, "Every state likewise has a duty to refrain from the threat or use of force to violate international lines of demarcation, such as armistice lines established by or pursuant to an international agreement to which it is a party or which it is otherwise bound to respect," end of quote. This declaration indicates that the prohibition of acquisition of territory by force could also apply to a territory where internationally recognized borders do not exist, but where parties are bound to respect certain international lines of demarcation. Article 2, Paragraph 4 of the UN Charter itself refers to the purposes of the United Nations, and Japan takes the position that Article 1, Paragraph 1 of the UN Charter must constitute an important context and object and purpose for the interpretation of Article 2, Paragraph 4. The Security Council has primary responsibility for the maintenance of international peace and security, and its view should be given significant weight in determining whether the prohibition of acquisition of territory by force applies to our territory. With regard to the occupied Palestinian territory, OPT, Preambular Paragraph 2 of the Security Council Resolution 242 emphasizes the inadmissibility of acquisition of territory by war. It also reaffirmed that the fulfillment of Charter principles requires the establishment of a just and lasting peace in the Middle East, which should include the application of principles, including, I quote, "withdrawal of Israeli armed forces from territories occupied in the recent conflict," end of quote. Japan is of the view that due consideration should be given to the relevant resolutions of the Security Council when examining the question of whether the prohibition of acquisition of territory by force applies to a certain territory. Mr. President, Madam Vice President, members of the Court, I thank you for your kind attention. I'd now like to give the floor to Professor Akande.
I thank Mr. Tomohiro Mika Nagi. I now give the floor to Professor Dapo Akande. Professor, you have the floor.
Mr. President, members of the Court, It's an honor to appear before you and to do so on behalf of Japan. The court has heard oral pleadings on a range of legal issues arising from Israel's actions in the occupied Palestinian territory. Japan focuses on a specific issue: the scope of the application of the principle of non-acquisition of territory by force. As Mr. Mikinagi has just set out, there are 3 points that are important with regard to the application of the principle. He has set out Japan's position on the first issue, namely the issue of which territory the prohibition of acquisition by force applies to. I will deal with 2 other issues relating to the principle. The second issue relates to what constitutes acquisition by force for the purposes of this principle. And the third relates to the relationship between the principle and the right to self-defense enshrined in Article 51 of the UN Charter. Let me begin with the question of what constitutes acquisition by force. Mr. President, the acquisition of territory by force consists of 2 elements, namely, 1, the establishment of control over the territory through forcible measures, and 2, the intention to appropriate that territory permanently. By acquisition or indeed annexation of territory by force, we mean a situation where a state attempts to acquire territorial title on the basis of forcible acts and where the state does not otherwise have valid title to that territory. The clearest case of annexation is an attempt to annex occupied territory de jure. In such a circumstance, the occupying state formally declares its sovereignty over the annexed territory. However, in the Wall Advisory Opinion, this court indicated that annexation could also take place de facto, where the actions of a state lead to what the court called a fait accompli. That is a situation on the ground which becomes permanent and which others are compelled to accept. A state seeking to avoid the denunciation of the international community may be incentivized to refrain from formally declaring the annexation of territory. Without clearly expressing its intention to annex the territory, it may seek to gain permanent control over a territory it occupies by engaging in military operations and taking a series of measures that make it materially impossible for other claimants to restore the status quo ante without risking death, physical injury, or damage to property. In other words, the occupying state may create what you called a fait accompli through these measures. The effect of the prohibition of acquisition of territory by force would be seriously undermined if states were allowed to circumvent the prohibition by simply obfuscating their true intentions to annex a territory and coercing other claimants to accept its permanent control over the territory through measures that create a fait accompli. It is therefore important to clarify in what circumstances such measures would constitute de facto annexation and amount to an unlawful attempt to acquire territory by force. In the Wall Advisory Opinion, the court considered that Israel's construction of a wall in the occupied Palestinian territory, as well as the creation of an administrative regime facilitating the establishment of settlements of Israeli citizens in areas lying between the Green Line and the wall, are the types of actions which would be tantamount to de facto annexation if it created a fait accompli that had effectively become permanent. Japan considers that certain acts which have continuous coercive effect in imposing control over territory may create a fait accompli and are likely to indicate intention to maintain permanent control over the territory. The following acts by occupying states may have such continuous coercive effects. First, large-scale alteration of the demographic composition of the territory, backed by military and other physical power, including through expropriation of land and eviction of the population. Second, the construction and continued maintenance by an occupying power of a network of physical infrastructure, particularly where these represent such significant financial investment that they may be deemed to be intended to subsist over a significant period of time. This may include, for example, roads, communication systems, healthcare facilities, or large-scale military or law enforcement facilities. Third, the continuous forcible seizure and exploitation of the natural resources, including water, by an occupying power. These acts do not necessarily cause death, injury, or destruction, but when they are implemented cumulatively at a significant scale and sustained for a long period, they would have continuous, even irreversible effect on the territory. In such a case, there may be evidence that the occupying state's intention is to permanently establish sovereignty over the relevant area, even if it is doing so incrementally. If such acts are accompanied by statements of state officials affirming the irreversibility of measures, or even asserting the intent to establish sovereignty over the occupied territories, the measures I've just mentioned are even more likely to indicate intention to acquire territory and thus amount to a prohibited attempt to acquire territory by force. Mr. President, members of the Court, having outlined Japan's views on what constitutes the acquisition of territory by force, permit me now to turn to the relationship between the principle of non-acquisition of territory by force and states' inherent right to self-defense contained in Article 51 of the UN Charter. The key question here is whether a state that does not otherwise have valid title to territory can acquire title through a use of force because the state claims to be acting in self-defense. Japan rejects this argument. Two alternative but interlinked arguments support this position. The first is that the principle prohibiting acquisition of territory by force precludes any acquisition of territorial title through force, regardless of whether that force is unlawful or permitted as an exercise of self-defense. Alternatively, and in any event, uses of force resulting in the annexation of territory will never be lawful as exercises of self-defense, since permanent annexation can never be a proportionate response to an armed attack. I begin by outlining the first argument. Japan submits that the principle prohibiting forcible acquisition of territory is properly understood as providing that the use of force is never a valid basis for acquiring title, even if the initial use of force by the state could have been lawful. This blanket prohibition is a necessary consequence of the complete abolition of the right of territorial conquest in the context of the UN Charter. In the Wall Advisory Opinion, the Court described the principle on the illegality of territorial acquisition resulting from the use of force as the corollary of the prohibition against the use of force itself. It is also connected to other fundamental principles of international law, in particular, the right to self-determination of peoples as set out in the Friendly Relations Declaration and recognized by this Court. It accordingly reflects a fundamental shift in international law in the 20th century, particularly after the entry into force of the UN Charter, which sought to minimize unilateral recourse to force in international relations. The prohibition on the use of force and the prohibition on acquiring territory by force form part of a coherent scheme with the right to self-defense. The right to self-defense provides for states to have recourse to force in order to defend their people and to preserve territory they already have. It does not allow a right to use force to gain additional territorial title. I would also like to highlight that a finding by the Court that conquest could confer title upon a state where force was used in self-defense would in practice be liable to widespread abuse. The proper scope of self-defense in international law is controversial. States frequently make contested claims that some use of force or another is lawful as an exercise of self-defense. States seeking to acquire territory by force could accordingly seek to exploit this ambiguity. This would threaten to undermine the principle and alongside it, the prohibition on the use of force. Japan's view on the proper scope of the principle is supported by the General Assembly's Friendly Relations Declaration, which states, and I quote again, because you've heard it many times, "The territory of a state shall not be the object of acquisition by another state resulting from the threat or use of force. No territorial acquisition resulting from the threat or use of force shall be recognized as legal." This part of the declaration contains no exception for force used in self-defense and does not limit the principle prohibiting territorial acquisition by force to unlawful uses of force. By contrast, in the sentence immediately prior to the one that I have just quoted, the declaration prohibits, and I quote, "military occupation resulting from the use of force in contravention of the provisions of the Charter," indicating that where the use of force is not prohibited by the Charter, military occupation may be lawful. This conclusion that the declaration endorses a blanket prohibition on acquisition of territory by force, is not affected by the declaration's subsequent reaffirmation that it, quote, "shall not be construed as affecting provisions of the Charter." The right of self-defense regulates the permissibility of uses of force in response to an armed attack, rather than dealing with the question of whether states can, through such use of force, acquire title to territory. The Friendly Relations Declaration accordingly clarifies that the answer to the latter question is no, without purporting to affect the scope of self-defense as a justification for the use of force. Mr. President, members of the Court, let me turn to the alternative point with regard to the relationship between the prohibition of territorial acquisition by force and the right of self-defense. And this is my final point. Annexation of territory can never meet the narrowly drawn requirements of the right of self-defense. As the Court has repeatedly pointed out, any purported exercise of the right to self-defense must be necessary and proportionate. Self-defense, by definition, can only justify the taking of temporary measures in order to achieve its aims. The aim of self-defense is limited to defending the attacked state and its people. Thus, even when a state has suffered an armed attack, it can never be proportionate to permanently deprive a people of its territory. In this regard, it is worth recalling that the acquisition of territory by force has been rejected in the context of states claiming to act in self-defense. The Security Council's response to Iraq's invasion and purported annexation of Kuwait in 1991 is worth noting. While demanding that Iraq, and I quote, rescind immediately its actions, end quote, the Security Council, in its Resolution 686, simultaneously affirmed, and I quote again, the commitment of all member states to the independence, sovereignty, and territorial integrity of Iraq and Kuwait, end quote. It's thus clear that the territory of Iraq had not become liable to annexation, even if states were to act in defense of Kuwait. Another relevant example is, of course, Security Council Resolution 242, which emphasized, quote, the inadmissibility of the acquisition of territory by war, end quote, without drawing any distinction between lawful and unlawful uses of force. Mr. President, members of the Court, I close my submissions by once again expressing Japan's position that the principle of non-acquisition of territory by force is an important norm which reinforces the Jus Cogens prohibition of aggression and is central to the maintenance of the rule of law among nations. This concludes the oral pleadings of Japan, and I thank you for your attention.
I thank the delegation of Japan for its presentation. I invite the next participating delegation, Jordan, to make its oral statement before the court and call His Excellency Ayman Safadi to the podium.
Bismillah ar-Rahman ar-Rahim. Mr. President, members of the court. On behalf of the Hashemite Kingdom of Jordan, I stand before you today as the evilness of the Israeli occupation of Palestine is being displayed in the bloodiest and most inhumane way. The Israeli aggression on Gaza, which your esteemed court has indicated warrants examination of plausible genocide, rages on. It is shattering thousands of lives. It is destroying a community of 2.3 million Palestinians who have already been suffering the oppression of occupation. 500,000 Palestinians in Gaza are at integrated food security phase classification level 5, facing starvation. This number is 4 times that in the whole world. In Gaza, Palestinians are dying by Israel's war. They are also dying from hunger and lack of medication as Israel prevents the delivery of food and medicine in violation of international humanitarian law and in defiance of the provisional measures you have ordered. This aggression has to end and end immediately. Those responsible for it must face justice. No country must be allowed to be above the law. Israel is acting and has been allowed to act in complete disregard of international law. That cannot continue. The occupation is unlawful. It is inhumane. It must end. Yet Israel has been systematically consolidating the occupation. It is blatantly denying Palestinians' right to self-determination. Its illegal unilateral measures are creating new facts on the ground that are killing all prospects for peace. Settlements illegal under international law, are growing in numbers and are spreading farther in occupied Palestinian land. The number of settlers has grown from 280,000 in 1993, when the Oslo Accords were signed, to over 700,000 today, nearly a 150% increase. Settler terrorism is a growing evil. Its victims are innocent Palestinians, their homes and their livelihoods. As the occupying power, Israel has a legal obligation to protect civilians, to preserve cultural and historical heritage, and to refrain from forcing demographic changes. It is constantly and intentionally violating this obligation. Israel is forcing demographic changes in the occupied Palestinian territory, destroying cultural and historical Palestinian heritage, confiscating and annexing Palestinian land, driving Palestinians out of their homes, their farms, their villages and their cities. It is illegally detaining thousands of children, men and women, and subjecting them to physical and mental torture, humiliation and abuse. Israel is violating the right of Muslims and Christians to freedom of worship. The Israeli government is severely restricting Muslims' right to pray at Al-Aqsa Mosque and is taking no real action to protect Christian priests from humiliation and abuse by Israeli extremists. Throughout decades of occupation, Israel has been working on changing the Arab, Muslim and Christian identity of the holy sites in occupied Jerusalem. Mr. President, members of the Court, peace is the right of all peoples of the region. But there can be no peace until occupation ends. There can be no peace until the right of the Palestinian people to self-determination is realized by the establishment and global recognition of an independent, sovereign Palestinian state with East Jerusalem as its capital on June 4, 1967 lines that can live side by side Israel in peace and security. The Hashemite Kingdom of Jordan has been relentlessly working for peace. We have suffered the consequences of conflict. We know the value of peace to us, to the region and to the world, and we know what it takes to achieve peace: the end of occupation and justice, freedom and statehood for the Palestinians. The two-state solution must be implemented and the Palestinian state must be recognized and accepted as a full member of the United Nations. And for the sake of peace and justice, Jordan will not relent in its effort to defend Muslim and Christian holy sites in occupied Jerusalem and to preserve their identity, as we shoulder our responsibilities under the historical Hashemite custodianship of the holy sites and the special role the Kingdom has towards them. Mr. President, members of the Court, Palestinians are being killed in the hundreds every day in Gaza and in the West Bank because Israel is not being held accountable for its war crimes and violation of international law. Children are undergoing surgery without anesthesia. 6-year-old Hind was left in the car for days next to the decaying bodies of her relatives whom Israel has killed. When medics finally arrived to rescue her, the Israeli occupation army killed them and killed her. This brutality that tortured and killed Hind is a constant reality of life under the Israeli occupation. No more. Rule that this brutality can be no more. Help deliver justice. Rule that the Israeli occupation, the source of all evil, must end. Thank you, Mr. President and members of the Court, and with your permission, I now yield to Dr. Ahmed Ziyadat, Jordan's Foreign Minister.
I thank His Excellency Ayman Safadi. I now give the floor to His Excellency Ahmed Ziyadat. Your Excellency, you have the floor.
Bismillah ar-Rahman ar-Rahim. Mr. President, members of the Court, it's an honor to appear before you on behalf of the Hashemite Kingdom of Jordan. There are 3 sections to my address. First, I will identify in overview Jordan and the Hashemite family's special role and interests in the Christian and Muslim holy site in Jerusalem for more than 100 years. Second, I will share mere fraction of the more than 3,000 pages of evidence placed before the court on Israeli violations. Third, I will briefly identify consequences of the Israeli violations. Jordan's written submission and evidence that have been placed before the court on these matters are adopted herein. Mr. President, members of the court, Jordan and the Hashemite royal family have a special role as the custodians of the Muslim and the Christian holy sites in Jerusalem. This special role is of paramount importance to the whole world because it is what keeps the peace and preserves the historic status quo at Jerusalem holy sites. Jerusalem is holy to Muslims, Christians, and Jews, who together make over 55% of world population. And it must be a city of peace. Preserving the historic status quo is the key to that peace and to containing global religious tensions. In performance of this role, Jordan administers the affairs of the Muslim holy sites in Jerusalem, including their maintenance and restorations. Jordan also takes all measures within its power to protect both the Muslim and the Christian holy sites. This special role is historic and internationally recognized, including by the US, the EU, Russia, the UK, the Vatican, the Islamic States, and Israel itself. I will briefly highlight its recognition by some of the most directly concerned states and bodies. The final declaration of the Joint Arab-Islamic Summit held this year states, I quote, "The blessed Al-Aqsa Mosque, with its entire area of 144,000 square meters, is an exclusive place of worship for Muslims, and it is under the management of the Jordanian Jerusalem Awqaf, within the framework of the historical Hashemite custodianship of the Islamic and the Christian holy sites." Article 2.1 of the Jordan Palestine Agreement of 2013 states, I quote, "His Majesty King Abdullah II, as the custodian of the Jerusalem holy sites, exerts all possible efforts to preserve the Jerusalem holy sites and to represent the interests of the holy sites in international forums and competent international organizations through visible legal means." Israel itself recognized Jordan's special role in the Treaty of Peace between Jordan and Israel of 1994. Article 9.2 of the treaty provides, in this regard, Israel respects the present role of the Hashemite Kingdom of Jordan in the Muslim holy shrines in Jerusalem. In 1924, the heads of churches in Jerusalem pledged allegiance to Sharif Hussein, reaffirming the Hashemite historic role in safeguarding and protecting Jerusalem holy places. The Hashemite kings of Jordan have performed that role ever since, and this allegiance has been repeatedly renewed. In 2013, His Holiness Pope Francis wrote to King Abdullah II to acknowledge His Majesty's custodianship. His Holiness stated, I quote, "I'm deeply conscious of His Majesty's internationally recognized role as custodian of the holy places of Jerusalem. The care of the holy places of Jerusalem has always been the highest priority of the Hashemite royal family. Turning to violations, Mr. President, members of the Court, I will share a few examples of Israeli violations in the holy sites since its occupation of East Jerusalem in June 1967. In June 1967, within days of its occupation, Israel demolished the historic Maghrabi Quarter, consisting of 153 houses, and expelled its residents in order to enlarge the space in front of the Al-Buraq Western Wall for Jewish prayers. Further, the Maghrabi Gate pathway, an ancient earthen ramp leading to Al-Aqsa Mosque, was demolished in 2004 and replaced by a wooden ramp in 2005. A serious and more serious violation that has been going on for decades is the extensive and systematic digging and tunneling works around and underneath Al-Aqsa Mosque, which threatens its structural integrity. On the 10th of September 2023, a UNESCO decision criticized Israel for failure to cease these activities and described them as persistent and illegal under international law. In April 2020, during the holy month of Ramadan, the Israeli forces raided Al-Aqsa Mosque during dawn prayers and attacked Palestinian worshippers with rubber bullets, stun grenades, and tear gas, causing more than 100 injuries to more than 100 people and made more 400 arrests. In the same month, the ancient Kibli Mosque was subject to a similar attack, and significant damage was caused to historic glass windows, the minbar, and the carpet. On December the 13th, 2021, and on March 31st, 2023, the patriarchs and the heads of churches of Jerusalem issued a statement expressing their concern that Christians and their holy sites have become the target of frequent and sustained attacks by Jewish radical groups with the aim of diminishing Christian presence. Mr. President, members of the Court, Israeli violations in the Muslims and Christian holy sites violate the rules of international law, including Articles 27, 53 of the Fourth Geneva Convention, as we have stated in depth in our written statement. Furthermore, Israeli violations of the historic status quo at the Muslim Christian holy sites in Jerusalem threaten their integrity. They inflame global religious tension and create confrontations along religious lines. Mr. President, members of the Court, thank you for your attention, and I now request that you invite Sir Michael Wood to the podium. Thank you.
I thank His Excellency Ahmad Ziadat. I now give the floor to Sir Michael Wood. Sir, you have the floor.
Mr. President, members of the Court, it's a great honour to appear before you and to do so on behalf of the Hashemite Kingdom of Jordan. Mr. President, Jordan fully maintains all that it said in its written statement and comments, including the conclusions, and I respectfully refer the Court to those pleadings for details of our position. In the time available, and given the hour, I shall be very brief in addressing 6 points. First, a small number of states have suggested that, giving its opinion, the Court should take care not to undermine the negotiating framework. Yet both in its 2004 opinion and in Kosovo, the Court rejected in no uncertain terms the argument that an advisory opinion could have a detrimental effect on negotiations. Your case law confirms that it is not for the Court to substitute its own views for those of the General Assembly on whether an advisory opinion may have such an impact. There is, moreover, no basis for making such an assessment in the present case. On the contrary, as the Court itself said in 2004, any negotiated solution must be achieved, and I quote, on the basis of international law. My second point concerns the right to self-determination. This right is well established in customary international law and is a norm of jus cogens, from which there can be no derogation. It goes hand in hand with the obligation to respect the territorial integrity of the self-determination unit, as well as the right to permanent sovereignty over natural resources. The competent organs of the United Nations have affirmed this right repeatedly over the years, demanding the establishment of a Palestinian state and the realization of the two-state solution. Regrettably, Israel's occupation has now lasted for well over half a century. During this period, Israel has intentionally breached fundamental principles of the law of occupation. The raison d'etre of these breaches is to deny the right to self-determination of the Palestinian people. The occupied Palestinian territory has been progressively fragmented. Its demographic composition has been and continues to be altered. Settlements and outposts expand rapidly, while the Palestinian people's access to natural resources is denied and water resources are depleted. All this, Mr. President, members of the Court, severely violates the Palestinian people's right to self-determination, including their right to an independent state on the 4 June 1967 lines, with East Jerusalem as its capital. The only way, Mr. President, for the right to self-determination to be exercised is for the occupation to come to an end. Turning to my third point, Israel's policies and practices also violate the law of occupation, which applies throughout the occupied Palestinian territory. Israel has engaged in a policy of progressively establishing settlements and so-called outposts. Israel's 2018 Basic Law declares, and I quote, "The state views the development of Jewish settlement as a national value and shall act to encourage and promote its establishment and consolidation." As others have said, 2023 was a record year for settlement expansion. And just recently, in late January, senior Israeli officials caused for settlement of Gaza and for the expanding settlement in the West Bank. Israel's settlements have created a patchwork of territorial units throughout the West Bank. They seek to create facts on the ground, and they undermine the establishment of a sovereign, independent, contiguous and viable Palestinian state. As many others have said, they are often accompanied by brutal settler violence, tolerated or even supported by the Israeli authorities. One effect is to instill a sense of terror and fear in Palestinians, leading to displacement from their own land. This brings me to the fourth point. Israel's policies and practices, when considered in their entirety, leave no doubt as to Israel's intention to annex the occupied Palestinian territory. The facts speak for themselves. Israel's 1980 Basic Law, which purported to annex Jerusalem de jure, the continued construction of the wall in the West Bank despite the court's 2004 opinion, the scale, infrastructure and location of Israeli settlements, the expansion of Israel's direct civilian legal authority across the West Bank, and the continued displacement of Palestinians and the difficulties they face to return to their homes. If there were any doubt, the map shown by the Prime Minister of Israel before the General Assembly last September, which you've seen earlier this week, and his rejection of the two-state solution confirm Israel's intention to annex. The annexation of any part of the occupied Palestinian territory is a serious breach of the prohibition of the acquisition of territory by force, a peremptory norm of general international law. Mr. President, my fifth point is that Israel's discriminatory laws and practices severely affect the lives of Palestinians and demonstrate a total disregard for the occupying power's duty to protect the rights and well-being of the Palestinian people. Specifically, the policy of discrimination constitutes a serious violation of treaty obligations and of customary international law, tantamount to apartheid. The Third Committee, the Human Rights Committee, and the Committee on Economic, Social and Cultural Rights have each urged Israel to amend the 2018 Basic Law so as to eliminate its discriminatory effects and to ensure equal treatment of all persons within the territory and subject to its jurisdiction, within its territory and subject to its jurisdiction. This has not been done. Discriminatory expropriation laws have been supplemented by a vast catalogue of military orders that have little or nothing to do with security or public order. Instead, they permit discriminatory treatment in practically every aspect of daily life, a discriminatory planning regime in which permits are routinely denied to Palestinians, the discriminatory practice of demolitions, and the use of zoning to designate military areas or so-called nature reserves, access to which is either denied to Palestinians or subject to Israeli permission. All of this is backed up by increasingly frequent interventions by Israeli armed forces to suppress protests, often with lethal fire, by the apparent impunity of those who engage in violence against Palestinians, by the use of excessive force, by attacks on health services, and by the ever-increasing arbitrary detention and ill-treatment of Palestinians, including children. Further, as explained in our written pleadings, Israel has engaged in acts that constitute crimes against humanity and has failed to prevent and punish such crimes. Mr. President, members of the Court, I now turn to question B and to my sixth and final point. What the General Assembly asks you to determine is whether the occupation as such is unlawful. Three essential principles should guide the Court in responding to question B. These principles are fundamental to the law of occupation, and they reflect Jus Cogens norms. First, occupation is by its very nature temporary. It must not become permanent or indefinite. Second, the occupying power cannot acquire sovereignty over the occupied territory, whether by annexation or in any other way. Third, the occupying power has the duty to respect the right to self-determination of the people of the occupied territory, as well as all their human rights. Israel's occupation contravenes each of these fundamental principles. Israel's policy of settlements, including the transfer of settlers, the confiscation of land, and the forcible displacement of Palestinian communities, evidences Israel's intention to occupy permanently and to annex territory that belongs to the Palestinian people. Israel's serious breaches of the right to self-determination, the principle of non-acquisition of territory by force, and the prohibition of discrimination, all Jus Cogens norms, leave no doubt that the occupation as a whole is unlawful. The occupation is being carried out for purposes contrary to international law. Mr. President, I now turn to the legal consequences arising from the unlawful occupation of the occupied Palestinian territory. A principal consequence is that Israel must end its occupation of the whole of the occupied Palestinian territory, that is the West Bank, including East Jerusalem, and Gaza. This must be done, as we said in our written pleadings, as a matter of urgency and as rapidly as possible. Another legal consequence is that all states are obliged not to recognise the unlawful situation created by Israel's policies and practices, and not to render any assistance that may serve to further those policies and practices. The content of these obligations was set out by Palestine on Monday in some detail. States must, moreover, cooperate with the competent organs of the United Nations to bring the unlawful occupation to an end. A further obligation binds states to investigate, prosecute and punish any individual subject to their jurisdiction for grave breaches of the Geneva Conventions and crimes against humanity. The United Nations, and especially the General Assembly and the Security Council, must take measures to end the illegal occupation, taking due account of the advisory opinion to be given. Before concluding, Mr. President, I must emphasise, in the light of what some others have said, that until Israel withdraws from the occupied Palestinian territory, it remains obliged to respect in full international humanitarian law and international human rights law. Israel's obligations under these bodies of law continue to apply, even though the occupation as such is unlawful. Mr. President, members of the Court, that concludes Jordan's submissions, and we thank you for your attention.
I thank the delegation of Jordan for its presentation, which brings to a close this morning's hearing. The Court will meet again this afternoon at 3 p.m. to hear Kuwait, Lebanon, Libya, Luxembourg, Malaysia and Mauritius. The sitting is adjourned. So the court meets this afternoon to hear Kuwait, Lebanon, Libya, Luxembourg, Malaysia, and Mauritius on the questions submitted to it by the United Nations General Assembly. Let me one more time recall that each delegation is kindly asked to respect the 30-minute time allocation for its presentation. This afternoon, the court will observe a short break after the presentation of Libya. I shall now give the floor to the Representative of Kuwait, His Excellency Mr. Ali Ahmad Brahim Al-Dafriri. You have the floor, Excellency.
Bismillah ar-Rahman ar-Rahim. Mr. President, honorable members of the court, it is a great honor to appear before you as the agent of the state of Kuwait in these proceedings. Kuwait deeply appreciates the extraordinary effort taken by the court to allow this hearing to proceed smoothly in light of the great number of participants. The current advisory proceedings are of extreme importance to the Palestinian people, Kuwait, the international legal order, and the international community as a whole. Kuwait has always advocated that peace fosters the observance of law and vice versa. Adherence to the United Nations Charter is an indispensable prerequisite for the definitive establishment of international peace. Indeed, peaceful relations are founded on accepted rules, and as such, peaceful relations among states are based on the provisions of the United Nations Charter. These include, notably, the principle of non-use of force and the peaceful settlement of disputes. These rules apply to all states. Respect for these fundamental rules contribute to the consolidation of international peace. Regrettably, the above-mentioned foundational rules have not been upheld in the case of Palestine. The conflict between the Palestinian and the Israel, hereafter referred to as the occupying power, is an illegal occupation conflict involving, on one side, an occupying power equipped with all military means, and the other side, an occupied nation without defensive capabilities, facing daily expulsion, human rights violation, and all sufferings associated with any occupation situation. Over the past decades, the situation between the Palestinians and the occupying power has been extremely tense, resulting in a serious human rights law and humanitarian law violation committed by the latter. Various intergovernmental and non-governmental organizations have documented these violations by publishing comprehensive reports. This climate of violence compromises any possibility of reasonably discussing the issue at stake. This is further exacerbated by the recent development in Gaza. The occupying power has waged an illegitimate war on the Palestinians in Gaza, characterized by numerous international law violations. The ongoing flagrant violations have been highlighted in a series of statements issued, among others, by the UN Secretary General, the UN High Commissioner for Human Rights, and the special procedures of the UN Human Rights Council. The unprecedented violence in Gaza is a result of 57 years of illegal occupation of the Palestinian territories, and it must stop. The late Emir of the State of Kuwait, His Highness Sheikh Sabah Al-Ahmed Al-Jaber Sabah, I'm sorry, Mr. President, summarized the situation in 2018 by stating, We ask the whole world by stating, quote, Mr. President. Quote, why do we ignore and do not implement Security Council resolutions? Why? We ask the whole world why the Palestinian people plight continues. Why the international community incapable of resolving this cause? Why does the victims continue to be portrayed Why does the victim continue to be portrayed as a killer according to Israel's norms? Why does Israel always escape punishment? Why have all these souls been lost amid absence of world conscience? Unquote. Sorry, Mr. President.
Sorry.
Mr. President, distinguished members of the court, it is in this context that Kuwait appears for the first time before the court, following the adoption by the UN General Assembly of resolutions 77247, requesting the court to deliver an advisory opinion on two legal questions. The first question asks the court to evaluate the illegality of the occupying power's specific policies and actions within its occupation of the Palestinian territories, while seeking the court's determination of the corresponding legal ramification. The second question addresses the core issue. Has the occupation become illegal? Kuwait will demonstrate the illegality of this occupation, underscoring the necessity of its cessation. Mr. President, honourable members of the court, my distinguished colleagues will now address these issues in greater depth. Second, first, His Excellency Ambassador Tariq Al-Bannai, permanent representative of Kuwait to the UN, will address why the court does have jurisdiction to deliver the advisory opinion requested by the UN General Assembly. He will also highlight certain legal practices and policies of the occupying power. Second, Her Excellency Tahani al-Nasser, Assistant Foreign Minister for Legal Affairs of Kuwait, will start by enumerating the grounds proving the illegality of the occupation of the Palestinian territories, hereafter referred to as the OPT. She will then focus on the legal consequences arising from the breaches of those fundamental rules. And finally, she will provide the court with a certain concluding remarks. Thank you, Mr. President, honourable members of the court, for the privilege of appearing before you. I now kindly ask you, Mr. President, to invite Ambassador Al-Bannai to address the court.
I thank His Excellency, Mr. Al-Dafiri. I now give the floor to His Excellency, Mr. Tariq Al-Bannai. You have the floor, Excellency.
Mr. President, honourable members of the court, it is a tremendous honour and privilege to appear before you on behalf of the State of Kuwait. 20 years have passed since the seminal Wall Advisory Opinion. Today, in these current proceedings, the question of the illegality of the occupation of the Palestinian territory is directly before the court. With your permission, I turn now to my first topic, focusing on whether the court has jurisdiction to render the advisory opinion requested. In Kuwait's view, the answer is a categorical yes. Indeed, the majority of submissions
in these proceedings argue in favor of the Court's jurisdiction. Article 65 of the Statute of the Court provides that the Court may render an advisory opinion, and I quote, on any legal question at the request of any organ or institution authorized by the Charter of the United Nations or in accordance with its provisions to request such an opinion, unquote. In turn, Article 96 of the UN Charter, quote, the General Assembly or the Security Council may request the International Court of Justice for an advisory opinion on any legal question, unquote. In practice, it is primarily the General Assembly that has most frequently utilized this procedure to date. After all, when the General Assembly decides to request the Court to deliver an advisory opinion, this means that the request reflects an important concern of the international community, seeking a legal answer. The Court itself observed that the General Assembly, within the scope of its peacekeeping responsibilities, has a broader perspective than that of the Security Council, as it also considers humanitarian, social, and economic aspects. An attentive look at the Court's jurisprudence points to the fact that, quote, only compelling reasons may lead the Court to refuse its opinion in response to a request falling within its jurisdiction, unquote. Although the Court has the discretionary power to refuse to respond to a request for an advisory opinion for reasons of judicial propriety, it has not availed itself of this option thus far. In the present case, it is incontestable that the questions included in the relevant General Assembly resolution are clearly specific questions of legal character. Any attempt to qualify them as non-specific or non-legal should fail. It is worth noting that the Court, in the Wall Advisory Opinion, rejected similar attempts. In essence, in the Wall Advisory Opinion, the central issue revolved around the construction of the wall and its impact on the right to self-determination of the Palestinian people. 20 years later, the context has broadened substantially. The Court is now tasked with determining the legal status of the ongoing occupation of the occupied Palestinian territory since 1967, given its persistence for over 57 years. Prior to addressing the next topic, I feel compelled to briefly refer to an argument certain states have made, fallaciously alleging that the issuance of an advisory opinion might undermine ongoing negotiations and peace processes. This argument, Mr. President, honourable members of the Court, is groundless and without merit. Kuwait has always underscored the importance of resuming peace negotiations with a view of reaching a just and comprehensive peace, based on the terms of reference of the peace process, the resolutions of the Security Council, and the Arab Peace Initiative. However, the relevant UN resolutions and the Wall Advisory Opinion make clear that any negotiations that take place must have as their objective the achievement of a just and lasting peace in accordance with international law. The Court has an important role to play in this regard by stating what the applicable rules of international law are, including the rights and obligations of the relevant parties, all states and the United Nations. This is exactly the purpose of the UN General Assembly resolution requesting the Court to deliver an advisory opinion. By doing so, the Court may in fact help revive negotiations and inspire a return to a peace process premised on international law. After all, the Court's advisory opinions shed light on complicated legal issues, appeasing tensions, uncertainties, and potential disputes. Mr. President, honourable members of the Court, I will now address our second topic, providing you with examples of the occupying powers' unlawful and egregious policies and practices in the OPT. In the interest of time, I will limit my presentation to 3 policies, which demonstrate the true nature of the illegal occupation. The first is forced displacement. The second relates to the illegal settlements on and the annexation of the Palestinian territory. And the third is discrimination at a scale and nature that amounts to apartheid. The remaining issues were discussed thoroughly in the written submission of Kuwait. In the 1948 Nakba, 750,000 Palestinians were forcibly displaced. And since then, millions more. The situation has deteriorated exponentially since the illegal occupation started in 1967. The occupying power has engaged in a forced displacement campaign against the Palestinians by demolishing their homes and confiscating their lands. Forced displacement violates international law. The occupying power is under the obligation to ensure that its operations in the OPT comply with the Fourth Geneva Convention of 1949 relative to the protection of civilians, persons in time of war, to which it is a party. Article 49 of this convention clearly prohibits, quote, forcible transfers, individual or mass, regardless of their motive, unquote, which includes forced displacements, as well as expulsions from the OPT. Furthermore, Article 53 of the same instrument prohibits the destruction of property. Finally, under Article 147, illegal transfers, destruction, and appropriation of property carried out on a large scale is prohibited. As Kuwait explained in its written submission, the occupying power has also committed other grave violations of international law, including the policy of settling parts of its population in the OPT. This unlawful policy has and continues to be deplorably promoted by the successive governments of the occupying power. Since 1967, the occupying power has embarked on an intensive campaign of colonization. Some settlements consisted of just a few prefabricated houses, while others expanded to become fully fledged small towns. In early 2023, there were around 730,000 Israeli settlers and over 280 Israeli settlements in the occupied West Bank, including 230,000 settlers in East Jerusalem. These settlements are sustained by a network of military checkpoints and restricted zones, as well as Jewish-only roads and highways, all of which limit gravely the lives and livelihoods of Palestinians and violate their fundamental human rights. Both the construction of settlements and the transfer of settlers to the West Bank and Gaza are grave violations of international law. In particular, Article 49 of the Fourth Geneva Convention, which states that, I quote, the occupying power shall not deport or transfer parts of its own civilian population into the territory it occupies, unquote. It is also noteworthy, Mr. President, that settlers in the OPT are not governed by the same laws that apply to the indigenous inhabitants of the territory. Jewish settlers are provided with special rights, facilities and subsidies that are denied to the indigenous Palestinian population. The occupying power's policy not only supports the existing settlers, but also incentivizes new settlers. The discriminatory policies and practice also violate the sovereignty of Palestinians over their natural resources, allowing the settlers and foreign companies to exploit the water and agricultural products of the occupied land without any benefit to the occupied population. It is widely recognized that the occupying power has codified its discriminatory policies and practices against Palestinians in its legislation. Specifically, it grants rights to Israeli Jews and systematically discriminates against Palestinians. For instance, the Land Acquisition Law of 1953 facilitates the alienation of confiscated Palestinian land for the benefit of various institutions of the occupying power. Quasi-public organizations, such as the Jewish Agency, engage in material discrimination, in particular through the allocation of confiscated Palestinian land to Israeli Jews. Mr. President, honorable members of the Court, thank you for your kind attention, and may I kindly ask that you invite Her Excellency Tahani al-Nasser to the podium.
I thank His Excellency Mr. Al-Bana, and now I give the floor to Her Excellency Mrs. Tahani al-Nasser. You have the floor, Excellency.
Thank you. Mr. President, distinguished members of the Court, it's a great honor and a privilege to appear before you on behalf of Kuwait. In the written submissions, the great majority of states participating in these proceedings, along with the 3 intergovernmental organizations, concluded that the occupation of the OPT is illegal. Kuwait firmly agrees with this view in its written submission. Kuwait identified several reasons proving the illegality of this occupation. I will provide a brief overview of these reasons for the Court. The occupation violates a series of jus cogens norms. First, the obligation to respect the right to self-determination of the Palestinian people. The right of people to self-determination is a right clearly recognized in international law as evidenced by several instruments and as submitted by 35 states and international organizations participating in these proceedings. This is articulated in Article 1.2 of the UN Charter, which define the purposes of the United Nations, including, I quote, to develop friendly relations among nations based on respect for the principle of equal rights and self-determination of peoples, and to take other appropriate measures to strengthen a universal peace, unquote. The same obligations are expressed in Article 1 of the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights. Second, Kuwait joined the participants in these proceedings who have concluded in their written submission that the ongoing military occupation of the OPT is illegal because it violates the jus cogens prohibition on the use of force. Third, the occupying power, by confiscating and annexing parts of the OPT, violates the prohibition on the acquisition of territory by force. This was underscored by 38 participants in the written proceedings. This fundamental norm was incorporated into Security Council Resolution 242 of 1967 and reaffirmed in Security Council Resolution 338 of 1973. Accordingly, the occupying power does not have the right to claim sovereignty over the OPT occupied since 1967. Fourth, the occupation is illegal because it obviously violates the law of military occupation. For instance, the occupation of the OPT is not of minimal duration. Facts clearly demonstrate that it is intended to be prolonged and ultimately permanent. A permanent occupation constitutes a serious violation of international law based on the verifiable evidence available to us. It's indisputable that this is precisely what is happening in the OPT. This prolonged occupation and identified violation of the Palestinians' right to self-determination renders the occupation illegal. Moreover, the conduct of the occupying power in the OPT violates the rules of international humanitarian law. In the World Advisory opinion, the Court stated that, quote, the Fourth Geneva Convention is applicable in the occupied Palestinian territories, unquote. The Court also determined that the Hague regulations are reflective of customary international law and thus applicable to the conduct of the occupying power in the OPT. Far from complying with the law of occupation, the actions of the occupying power disregard international law. These actions include, inter alia, the establishment of settlements in the OPT, confiscation of Palestinian public and private property, and its failure to protect Palestinians from violence caused by state actors and private parties, including, inter alia, armed illegal settlers. Finally, the occupation violates the jus cogens prohibition of apartheid. 21 participants in these proceedings supported this in their written submissions, while 14 maintained that the situation of apartheid qualifies the occupation as illegal under international law. The prohibition of apartheid is evidenced in various sources of international law. The occupying power is bound by the 1965 Convention on the Elimination of All Forms of Racial Discrimination, to which it is a party. Furthermore, it shall abide by the prohibition of apartheid as enshrined in 1973 International Convention on the Suppression and the Punishment of the Crime of Apartheid, which codifies customary international law. Several voices and independence experts have warned that the occupation of the OPT amounts to a regime of apartheid. For instance, in March 2022, the Special Rapporteur on the situation of human rights in the Palestinian territories occupied since 1967, in his report reached a similar conclusion. Kuwait, respectively, suggested that the above violations cannot be reconciliated with the fundamental rules of international law. Hence, the occupation must be declared illegal in accordance with international law and the relevant UN Security Council resolution. It must stop. This will guarantee the right of the Palestinian people to be available state and along 1967 borders with East Jerusalem at its capital. Mr. President, members of the Court, the legal analysis of the question involved in these advisory proceedings demonstrate that the occupation of the OPT is illegal, in contravention of the fundamental rules of international law. It is written submission, Kuwait did address the legal consequences arising from the occupying powers, numerous and long-standing violations of these rules. Please allow me to provide with a view d'ensemble. As indicated, the action of the occupying power and the occupation as a whole are plenarily incompatible with the rights of the Palestinian people and obligations of the occupying power under international law. Its breaches of these rights and obligations engage the occupying power's international responsibility. The occupying power must therefore take several measures. First, it must provide Palestinians with relief in accordance with the principles of customary international law on the responsibility of states for internationally wrongful acts. This must be achieved through the immediate cessation of its illegal occupation. Second, the occupying power must give assurance and guarantees of non-repetition of its international law violations. The occupying power shall commit itself to not repeating the same breaches in the future. Finally, the occupying power is under the obligation to make full reparation for the injury caused by its occupation and discriminatory policies and practices. As for all other states, they are all obliged to refrain from acknowledging the legality of the situation created by the illegal occupation and associated illegal policies and practices. They shall also abstain from offering support or assistance to sustain the circumstances stemming from the unlawful occupation and associated actions. Third, state shall also contribute to safeguarding the Palestinian population against war crimes, genocide and crimes against humanity, and ensure that those responsible for crimes committed within the framework of illegal occupation are held accountable. In turn, the UN shall refrain from acknowledging the legality of the situation resulting from the illegal occupation and associated actions. The UN shall also refrain from offering support or assistance to prolong the situation and should instead cooperate to bring an end to the illegal occupation. Mr. President, honourable members of the Court's advisory opinion is now more than ever necessary to put an end to the illegal occupation of the OPT. Kuwait has sought to concisely summarize the grounds for finding that the occupation is illegal as a whole, and submits that each ground of illegality shall form part of the court's dispositif. We are confident that the court will assess Kuwait's written submission and oral statement as an expression of its faith in justice, its support for the rule of law, and its desire for peace for all states in the region. Mr. President, honourable members of the court, this ends Kuwait's oral statement. Kindly allow me, on behalf of Kuwait's delegation, to thank the court for its kind attention, as well as the registry staff and the interpreter for all their support. Thank you very much.
I thank the delegation of Kuwait for its presentation. J'invite maintenant la délégation de l'État participant suivant, le Liban, à prendre la parole devant la Cour. Appelle son Excellence, M. Abdesattar Issa Alabar. Excellence, vous avez la parole.
Monsieur le Président, Mesdames et Messieurs membres de la Cour, c'est un immense honneur de m'adresser à vous afin d'exposer les observations orales du Liban au sujet des conséquences juridiques découlant des politiques et pratiques d'Israël dans le territoire palestinien occupé, y compris Jérusalem-Est. C'est un sujet de la plus grande importance pour mon pays, ainsi que l'ensemble de la communauté internationale. Le nombre record des demandes d'intervention orale devant votre auguste Cour en est la preuve la plus probante. Ayant exposé par écrit les vues du Liban sur les divers aspects juridiques des questions posées, et par respect des règles pratiquées lors des plaidoiries qui invitent à la brièveté, je me contenterai d'élaborer 3 points qui ont pris de l'importance vu la gravité des événements qui se déroulent depuis le mois d'octobre dans le territoire palestinien. Ces 3 points sont l'opportunité de l'intervention de la Cour, le caractère impératif des normes de droit international violées par Israël, en particulier l'interdiction du recours à la force et le droit à l'autodétermination, et enfin les conséquences juridiques qui découlent de ces violations. L'opportunité de l'intervention de la Cour. Monsieur le Président, Mesdames et Messieurs, on est à quelques mois du 20e anniversaire de la vie historique de votre illustre Cour, que votre illustre Cour a rendu au sujet de l'édification d'un mur dans le territoire palestinien occupé. Or, certains États avaient évoqué au cours de la procédure de cet avis, comme ils le font actuellement, une observation qui incite la Cour à ne pas rendre son avis, car son intervention bloquerait des négociations en cours entre les parties, qu'elle risquerait de rendre beaucoup plus difficile ou même impossible l'accommodement politique nécessaire, qu'il y a une feuille de route à suivre. Nous voici 20 ans après, toujours sans solution négociée, sans négociation tout court, par contre avec des milliers de morts et la destruction massive d'infrastructures civiles. Demander à la Cour de ne pas intervenir, de ne pas rendre son avis consultatif au nom d'un processus de négociation bilatérale à protéger, d'une solution politique à préserver, est un argument pervers qui crée un antagonisme entre le politique et le juridique, alors qu'ils sont dans toute société, y compris la société internationale, 2 éléments complémentaires en relation dialectique. Le droit cadre le politique, empêche sa dérive, que ce soit au niveau public ou privé. Le droit garantit un minimum de justice dans les relations. Madame Chemillier-Gendreau avait en 2004 clairement décrit ce fait en plaidant devant cette Cour, je cite, « Le politique, c'est la confrontation des subjectivités des différents acteurs sociaux dans un processus direct qui révèle un rapport de force que rien ne vient atténuer. Le juridique est le transfert de ce heurt des subjectivités en référence à un standard préalablement établi, la norme de droit, et devant une instance tierce offrant des garanties d'objectivité. La confrontation à la norme de référence effectuée par un tiers impartial introduit cet espace d'objectivité qui permet de corriger la situation de fait. Fin de citation. Cette objectivité, Monsieur le Président, Mesdames et Messieurs membres de la Cour, c'est cette objectivité, Monsieur le Président, Mesdames et Messieurs membres de la Cour, qu'on est venu chercher encore une fois auprès de vous. Permettez-moi de passer au deuxième point, le caractère impératif des normes violées par Israël. Comme on l'a déjà mentionné dans nos observations écrites, la notion de norme impérative jusqu'au gens s'est précisée grâce au travail laborieux de la Commission de droit international depuis 2016. En parlant du travail de la Commission, je voudrais répondre à l'observation émise par certains États qui veut que les projets d'articles ou conclusions proposés par cette Commission ne puissent être considérés comme des concepts établis. Cette observation, Mesdames et Messieurs, minimise le rôle que joue cet organe au nom de l'Assemblée générale des Nations unies dans le développement et la codification du droit international. J'invite la Cour à examiner mon observation sur l'observation à la lumière de l'article 38 de son statut. Revenons aux normes impératives. La Commission avait établi une liste non exhaustive de 8 normes impératives. Quand le Liban avait présenté son exposé écrit, il considérait qu'Israël violait au moins 4 des 8 normes citées. Depuis, et vu les horreurs que subissent les Palestiniens à Gaza, Israël est accusé, triste ironie de l'histoire, de violer une cinquième norme des 8, et pas la moindre, l'interdiction du génocide. Comme je l'ai annoncé au début, je me limiterai à 2 des normes impératives mentionnées dans notre exposé écrit, l'interdiction du recours à la force et le droit à l'autodétermination. La justification de ce choix me paraît évidente. La violation de ces 2 normes par Israël est la cause directe ou indirecte de ces violations du restant des normes mentionnées dans notre exposé écrit, que ce soit les normes du droit international humanitaire, les droits humains ou l'interdiction de l'apartheid. Qu'Israël cesse son occupation du territoire palestinien, y compris Jérusalem-Est, qu'il accepte le droit du peuple palestinien à l'autodétermination et toutes ces autres violations disparaîtront. Je voudrais ajouter à ce sujet que nombreux sont les États qui ont évoqué, je dirais même insisté, dans leurs observations écrites et orales sur le caractère prolongé de l'occupation israélienne afin de la qualifier comme une annexion illégale des territoires palestiniens. C'est une argumentation valable et correcte, Monsieur le Président, mais elle doit être prise comme faisant partie des circonstances aggravantes du crime, pas le crime même, qui est le crime de l'agression. En effet, depuis 1945, l'usage de la force est strictement réglementé en droit international. Et Israël commet depuis 1967 un crime d'agression où il occupe illégalement des territoires avant de les annexer. En d'autres termes, l'occupation des territoires qui résulte d'un usage illégal de la force est illégale, quelle que soit sa durée. Nous voilà face à la première norme impérative violée par Israël, l'interdiction du recours à la force. L'interdiction du recours à la force est une des normes impératives bien établies et elle est clairement énoncée par l'article 2, paragraphe 4 de la Charte des Nations Unies qui stipule que les membres de l'organisation s'abstiennent dans leurs relations internationales de recourir à la menace ou à l'emploi de la force, soit contre l'intégrité territoriale ou l'indépendance politique de tout État, soit de toute autre manière incompatible avec les buts des Nations Unies. L'Assemblée générale avait adopté en 1974, par sa résolution 3314, une définition de l'agression qui énumère d'une façon non exhaustive plusieurs modalités de recours illicite à la force. Selon l'annexe de la résolution 3314, est une agression toute occupation militaire, même temporaire, toute annexion par l'emploi de la force du territoire ou d'une partie du territoire d'un autre État, le blocus des ports ou des côtes d'un État. Ainsi, l'occupation des territoires palestiniens par Israël et son blocus de la bande de Gaza constituent des actes d'agression. Ce fait a été constaté à maintes reprises par le Conseil de sécurité des Nations unies, qui ne cesse depuis 1967 de demander à Israël de mettre fin à son occupation. L'Assemblée générale, de son côté, est plus explicite dans sa condamnation de l'occupation israélienne des territoires palestiniens. Elle a déclaré récemment, par exemple, l'inadmissibilité de l'acquisition de territoires par la force et donc le caractère illégal de l'annexion de toute partie du territoire palestinien occupé, y compris Jérusalem-Est, qui constitue une violation du droit international. La Cour a toujours affirmé de son côté l'illicéité du recours à la force et de l'acquisition des territoires par la force, y compris dans son avis consultatif sur l'édification du mur, où elle a également rappelé le caractère coutumier de cette interdiction. Certains pourraient émettre des doutes sur l'application de la norme interdisant le recours à la force sur la base que c'est une norme interétatique, insinuant que les territoires palestiniens occupés ne font pas partie d'un État. À cela, on peut répondre, mesdames et messieurs, que le Liban, ainsi que plus de 140 États membres des Nations unies, reconnaissent l'État de Palestine et Jérusalem-Est comme sa capitale. L'État de Palestine est membre de plusieurs organisations internationales comme l'UNESCO, l'OIAC, l'OIC, la Ligue des États arabes et la CPA, et la Palestine est membre observateur des Nations unies, dont le secrétaire général, M. Guterres, déclarait il y a moins d'un mois que le droit du peuple palestinien d'édifier son propre État pleinement indépendant doit être reconnu par tous. Et tout refus d'accepter la solution des deux États par quelque partie que ce soit doit être fermement rejeté. Ce serait d'ailleurs une occasion opportune pour la Cour de donner son avis sur ce point. Dans tous les cas, Monsieur le Président, Mesdames et Messieurs membres de la Cour, l'interdiction du recours à la force ne se limite pas en droit international aux relations entre États, mais à toute utilisation contraire aux principes et buts de la Charte des Nations unies. Or, Israël continue son occupation et ses politiques qui visent clairement à annexer les territoires palestiniens. Il encourage la colonisation, la confiscation des terres, la destruction des bâtiments publics et privés, afin de rendre sa présence un fait accompli et irréversible. Ceci malgré toutes les résolutions successives du Conseil de sécurité, à commencer par la résolution 242. Vu ce qui précède, le Liban prie la Cour de considérer une nouvelle fois qu'Israël viole le principe fondamental de l'illicéité du recours à la force et son corollaire de l'illégalité d'annexion des territoires par la force. Le droit à l'autodétermination. Le Liban considère que le droit du peuple palestinien à l'autodétermination est irréfutable et on ne peut trouver de mots plus éloquents que ceux employés par la Cour pour affirmer cette réalité. Je cite, « La Cour observe que l'existence d'un peuple palestinien ne saurait plus faire de débat et que parmi les droits de ce peuple figure le droit à l'autodétermination. » Fin de citation. Le droit à l'autodétermination est une norme impérative de droit international consacrée dans divers textes, y compris la Charte des Nations unies, qui établit ce droit comme un des fondements des relations amicales entre les nations. Or, ce socle du droit international moderne comporte plusieurs facettes, toutes violées par Israël. La Cour s'est penchée dans son avis consultatif sur les effets juridiques de la séparation de l'archipel des Chagos de Maurice en 1965, sur la nature et surtout le contenu du droit à l'autodétermination. Elle a rappelé que le droit à l'autodétermination est une règle coutumière et que la résolution de l'Assemblée générale 1514 avait un caractère déclaratoire. Cette résolution, adoptée en 1960, fut l'un des premiers textes à préciser le contenu et la portée du droit à l'autodétermination. On y affirme que l'autodétermination des peuples implique qu'ils puissent déterminer librement leur statut politique et poursuivre leur développement économique et social. La résolution mentionne aussi qu'il faut mettre fin à toute action armée et à toute mesure de répression, de quelque sorte qu'elle soit, dirigée contre les peuples dépendants, pour permettre à ces peuples d'exercer pacifiquement et librement leur droit à l'indépendance complète et l'intégrité de leur territoire national sera respectée. Elle indique clairement aussi que toute tentative visant à détruire partiellement ou totalement l'unité nationale et l'intégrité territoriale est incompatible avec les buts et principes de la Charte des Nations Unies. Par ailleurs, le premier article commun au pacte de droits civils et politiques et le pacte des droits économiques et sociaux et culturels affirme aussi le droit des peuples à l'autodétermination et reprend les principaux éléments qui constituent ce droit. Comme je l'ai évoqué précédemment, le Liban considère qu'Israël viole tous les éléments constitutifs du droit du peuple palestinien à l'autodétermination, qui sont 1. L'indépendance politique et économique, 2. La souveraineté permanente sur les richesses et ressources naturelles, et 3. L'intégrité territoriale. La tergiversation d'Israël depuis des décennies, malgré tous les accords qu'il a conclus et les appels de la communauté internationale à reconnaître l'indépendance de l'État palestinien, est une violation continue du premier élément du droit à l'autodétermination. La politique israélienne de confiscation de territoires agricoles, d'exploitation des ressources hydrauliques et minières des territoires palestiniens occupés est une violation continue du deuxième élément constitutif du droit à l'autodétermination, qui est la souveraineté permanente des peuples sur leurs ressources naturelles. Le troisième élément constitutif du droit à l'autodétermination, l'intégrité territoriale, a été rappelé par la Cour quand elle a déclaré que le droit à l'autodétermination du peuple concerné est défini par référence à l'ensemble des territoires non autonomes et ainsi que le souligne le paragraphe 6 de la résolution 1514. La Cour considère que les peuples des territoires non autonomes sont habilités à exercer leur droit à l'autodétermination sur l'ensemble de leur territoire, dont l'intégrité doit être respectée par la puissance administrante. Or, Israël, par sa politique de colonisation et de construction d'infrastructures qui relient ces colonies, grignote et morcelle les territoires palestiniens, y compris à Jérusalem. Cette atteinte systématique et continue à l'intégrité du territoire palestinien est constatée et documentée dans plusieurs rapports d'enquête internationale. On arrive maintenant, Monsieur le Président, Mesdames et Messieurs, au troisième point. Les conséquences juridiques des violations d'Israël. Les points précédents montrent qu'Israël continue de violer des normes impératives de droit international, des normes qui créent des obligations erga omnes. La Cour avait déjà constaté ce fait dans son avis consultatif en 2004, où elle a déclaré qu'au rang des obligations internationales violées par Israël figurent des obligations erga omnes. De telles obligations, par leur nature même, concernent tous les États. Et vu l'importance des droits en cause, tous les États peuvent être considérés comme ayant des intérêts à ce que ces droits soient protégés. La nature des obligations violées entraîne dans ce cas une responsabilité spécifique d'Israël, mais aussi une responsabilité des États tiers. En effet, le caractère continu et systématique des actions politiques israéliennes constitue une violation aggravée qui entraîne 3 genres d'obligations pour les États, selon l'article 41 du projet d'article sur la responsabilité de l'État recommandé par l'Assemblée générale des Nations unies en 2001. Ainsi, on abordera les conséquences juridiques vis-à-vis d'Israël, puis vis-à-vis des États tiers. Les conséquences juridiques vis-à-vis d'Israël. Comme je l'ai mentionné plus haut, Israël commet une violation grave du droit international public, selon la définition de l'article 40 du projet d'article sur la responsabilité de l'État pour faits internationalement illicites. Ces violations étant systématiques et continues, Israël est tenu de cesser ces actes illicites et d'offrir des assurances de non-répétition, selon l'article 30 du projet d'article sur la responsabilité de l'État. Concrètement, Israël est tenu dans ce cas, afin de respecter le principe du non-recours à la force et son corollaire de l'inadmissibilité de l'annexion des territoires, de démanteler les colonies dans les territoires palestiniens occupés et de se retirer de ces territoires. La Cour avait déjà affirmé dans son arrêt sur les conséquences juridiques de l'édification d'un mur dans le territoire palestinien occupé qu'Israël est en conséquence tenu de restituer les terres, les vergers, les oliveraies et les autres biens immobiliers saisis à toute personne physique ou morale. Israël est tenu aussi de cesser sa violation du droit à l'autodétermination du peuple palestinien, de mettre fin à son occupation des territoires palestiniens et de reconnaître l'État de Palestine. Par ailleurs, Israël restera dans une situation illégale tant qu'il n'applique pas les résolutions du Conseil de sécurité qui traitent des différents aspects de son occupation des territoires palestiniens. En effet, mesdames et messieurs, la Cour a déjà précisé en 2004, je cite, « Lorsque le Conseil de sécurité adopte une décision au terme de l'article 25 conformément à la Charte, il incombe aux États membres de se conformer à cette décision, notamment aux États qui ont voté contre elle et aux membres des Nations unies qui ne siègent pas au Conseil. Ne pas l'admettre serait priver cet organe principal des fonctions et pouvoirs essentiels qu'il tient de la Charte. » Fin de citation. On peut dire, mesdames et messieurs, de tout ce qui précède, que l'occupation israélienne du territoire palestinien est illégale, tant dans sa conduite que dans son but. Par conséquent, Israël est dans l'obligation de mettre un terme immédiat et inconditionnel à cette situation illégale, dont il est internationalement responsable, et de fournir réparation. Les conséquences vis-à-vis des États tiers. Vu que les normes violées par Israël sont des normes impératives, ces violations affectent tous les États du fait de leur caractère erga omnes. Le projet d'article sur la responsabilité de l'État pour faits internationalement illicites stipule dans son article 41 que 1. Les États doivent coopérer pour mettre fin par des moyens licites à toute violation grave de l'article 40. 2. Aucun État ne doit reconnaître comme licite une situation créée par une violation grave au sens de l'article 40, ni prêter aide ou assistance au maintien de cette situation. La Cour avait déjà confirmé ces éléments qui incombent aux États en cas de violation d'obligations erga omnes, quand elle déclara dans son avis sur les conséquences juridiques de l'édification d'un mur dans le territoire palestinien occupé en 2004, je cite, « Vu la nature et l'importance des droits et obligations en cause, la Cour est d'avis que tous les États sont dans l'obligation de ne pas reconnaître la situation illicite. Ils sont également dans l'obligation de ne pas prêter aide ou assistance au maintien de la situation. Il appartient par ailleurs à tous les États de veiller, dans le respect de la Charte et du droit international, à ce qu'il soit mis fin aux entraves à l'exercice par le peuple palestinien de son droit à l'autodétermination. » Fin de citation. De ce qui précède, on peut dire que les conséquences des violations israéliennes sur les États tiers sont les suivantes. Premièrement, les États doivent coopérer par tout moyen licite afin qu'Israël se retire des territoires palestiniens occupés, arrête sa politique d'expansion des colonies et démantèle les colonies existantes. Et enfin, reconnaissent le droit à l'autodétermination du peuple palestinien. Deuxièmement, les États ne doivent pas reconnaître la situation de fait accomplie qu'Israël a créée dans les territoires palestiniens occupés et surtout le changement du statut et de la situation démographique de la ville de Jérusalem. En somme, l'occupation israélienne du territoire palestinien est illégale et doit cesser immédiatement et sans condition. En conséquence, les États tiers et les organisations internationales sont tenus de soutenir sans délai les efforts visant à mettre un terme immédiat et inconditionnel à cette occupation et de s'abstenir de toute action ou omission qui contribue au maintien de la situation illégale. En parlant des organisations internationales, et vu que la Cour est censée répondre à des questions adressées par l'Assemblée générale des Nations unies, une responsabilité particulière incombe à cette organisation. L'Organisation des Nations unies, et en particulier l'Assemblée générale et le Conseil de sécurité, devraient prendre les mesures nécessaires pour assurer la mise en œuvre de leurs résolutions pertinentes sans aucun retard et examiner les mesures supplémentaires nécessaires pour mettre fin à tout obstacle à la réalisation par le peuple palestinien de son droit à l'autodétermination, mettre fin à l'occupation, la colonisation et l'annexion prolongée du territoire palestinien par Israël, notamment aux mesures visant à modifier la composition démographique, le caractère et le statut de la ville sainte de Jérusalem. Mesdames et Messieurs, le Liban prie la Cour de se considérer compétente pour répondre à la demande d'avis consultatif contenue dans la résolution 77/247 de l'Assemblée générale et de le faire à la lumière de ses observations écrites et orales. Mr. President, ladies and gentlemen, members of the Court, the late Pope John Paul II once said, "If you want peace, work for justice. If you want justice, defend life. If you want life, embrace the truth." As the highest judicial authority in our globalized world, Lebanon urges you to help in giving justice to the Palestinian people so we can have peace in the Middle East. Thank you.
Je remercie la délégation du Liban pour son exposé. I invite the next participating delegation, Libya, to make its oral statement before the court. I thus call upon Professor Ahmad Al-Gihani to take the floor. You have the floor, sir.
Mr. President, distinguished judges, good afternoon. It is my honor to be here before the court. It is the first time with my delegation in representing the Libyan submission to your court. First, let me say that the suffering of the Palestinian people, and in particular in Gaza Strip, nowadays are a clear evidence of consequences of the failure to address the Palestinian cause. The world is witnessing a large-scale and systematic heinous crimes being committed by the occupying power force, depriving the civilian population of food, water, and essential supplies. The aggression of the power of occupying power has not spared children, women, elderly people. There is no safe place for the people in Gaza to go to. The crimes committed by Israel tantamount to the crime of genocide and other international crimes stated in the Article 5 and 6 and 7, 8 for the Rome Statute. This call on the international community as a whole and on organs of the United Nations to put an end to this tragedy and take concrete steps in order to enable the Palestinian people to realize their legitimate rights of self-determination. Therefore, we believe guidance from the court as the highest judicial organs in the United Nations, and it is necessary and important. The presentation of the state of Libya before your court will address the following points. First, the jurisdiction of the court, then the legality of the occupation of the Palestinian territory, then the consequences of the Israeli illegal actions, and then the summit. We can start from the first point, that the jurisdiction of the court. As you know, Mr. President, member of the court, that the Article 96, paragraph 1 of the United Nations Charter provides that the General Assembly or the Security Council may request the International Court of Justice to give an advisory opinion on any legal question. On the other side, the Article 65, paragraph 1 of the court's statute further stipulates that the court may give an advisory opinion on any legal question at the request of whatever body may be authorized by or in accordance with the Charter of the United Nations to make such request. These two provisions are, according to our view, sufficient to establish the competence of the General Assembly to request the advisory opinion from the court and the jurisdiction of the court to give the requested opinion. We go to the second point, the applicable law. The international humanitarian law. First, the international humanitarian law. It is, as you know, settled that 1949 Geneva Convention relative to the protection of civilian persons in times of war apply to the OPT, as noted by the court in the Wall opinion. In addition of that, the 1907 Hague Regulation have become a part of customary law and therefore apply to the OPT, despite the Israeli argument that the Fourth Geneva Convention does not apply to the OPT. The court found, as a matter of treaty law, that does indeed apply, as it would to say, and occupied territory to prevent an armed conflict arising between two or more high contracting parts. In 2001, the Conference of High Contracting Parties reaffirmed the applicability of the Fourth Geneva Convention in the occupied Palestinian territory, including East Jerusalem, Quds, and called inter alia upon the occupying power to immediately refrain from committing grave breaches involving any of the acts and mentioned in the Article 147 of the Fourth Geneva Convention, such as killing, torture, deportation, depriving of the rights of fair and regular justice and trial, extensive destruction and appropriation of the property not justified by military necessity. Plus that is applied the international human rights law. A variety of international human rights treaties apply to the proceedings. Among the most important of these are the International Covenant of Civil and Public Rights, International Covenant on Economic, Social and Cultural Rights, the International Convention on Elimination of All Forms of Racial and Discrimination, the International Convention of the Elimination of All Forms of Discrimination Against Women, CEDAW, the Convention on All Rights of the Child, and the Convention Against the Torture and other forms of cruel, human, degrading treatment and punishment. Both states, Palestine and the occupying force, are parties to these treaties. Established norms of general international law applicable to the proceedings. As stated by the International Law Commission, norms of general international law, jus cogens, embody three essential characters. One, they protect the value of fundamental to the international legal order shared by the international community as a whole. The second, They are universally applicable by virtue of their non-derogability, since states cannot derogate from them by creating their own special rules that conflict with them. They are superior on other norms of international law, entailing obligation of an erga omnes character. The court itself has recognized the erga omnes character of such obligation. These are the norms. First, the inadmissibility of the territorial acquisition by threat or by use of the force. The prohibition against the threat or use of the force against the territorial integrity or political independence of another state is enshrined in the Article 2, Paragraph 4 of the United Nations Charter and is an essential cornerstone of the international legal order. The article, I quote, the Article 2.4 provides that all members shall refrain in their international relation from the threat or use of force against the international integrity or political independence of any state, or in any other manner in consist with the purpose of the United Nations. In case of the armed activity on the territory of the Congo, the court stated that the prohibition of the use of force is a cornerstone of the United Nations Charter. Then we go to the second paragraph, which is the prohibition against racial discrimination and apartheid. The prohibition of racial discrimination and apartheid is reflected most in CERD, as the court has very recently underlined that 182 states are parties in the CERD, a fact which confirms that universal character of the convention. Those parties include both the state of Palestine and the occupying force. It is well established that the prohibition of the racial discrimination forms part of customary law and has long been recognized as premonitory norm. The court in Barcelona Traction considered the prohibition of the racial discrimination to be a norm of erga omnes character, stating that such obligations derive from, example, contemporary international law, from the outlawing of acts, aggression, and genocide, as also from the principle and rules of concerning the basic rights of the human person, including protection from slavery and racial discrimination. Third, the obligation to respect the right of the self-determination. The right of self-determination exists in customary international law and recognized by the United Nations Charter, as well as in the ICCPR and ICESCR. It must be also stated that the obligation to respect the people's right of self-determination is premonitory principle of the general international law. As the court noted in the East Timor case, that right in self-determination is one of the essential principles of contemporary international law, enjoying an erga omnes character. The United Nations General Assembly has repeatedly confirmed the right of Palestinian people to self-determination. For example, the resolution 2672 of the 8th December 1970. It recognized that the people of Palestine are entitled to equal rights and to self-determination in accordance with the Charter of the United Nations, and that full respect for the inalienable rights of the people of Palestine is an indispensable element on the establishment of a just and lasting peace in the Middle East. Mr. President, members of the court, now we come to the illegal illegality of the Israeli occupation of the Palestinian territory. The Israeli 6 decades occupation of Palestinian territory is a continuing gross and systematic breach of its legal obligation under the United Nations Charter and the general international law, also international humanitarian law, international human rights law, and customary international law, including the violation of at least 3 premonitory norms of general international law, of jus cogens and erga omnes charter. It shows that Israel has annexed and plans to continue to annex Jerusalem, Al-Quds, and the rest of the West Bank that has composed systematic and comprehensive racial discrimination tantamount to apartheid against the Palestinian people, based on their race, and that it has denied their right to self-determination in their own land. In view of these policies and practices, Israel's occupation of the OPT is unlawful, rendering Israel's continued presence in the OPT and internationally wrongful act as seriously breaches the last 3 premonitory norms of the general international law. Derogation from which is not permitted. Israel's occupation of the Palestinian territory seriously breaches premonitory norms of the general international law, and the occupation of the OPT seriously breaches the at least 3 premonitory norms of general international law, derogation from which is not permitted. On the matter of self-determination, the occupying power has not only denied, Israel has not only denied the right of the Palestinian people to self-determination, but actively tried to suppress and to extinguish it even after the court's ruling in 2004. That Israel has under obligation, erga omnes, to respect the right of the Palestinian people to self-determination. Israel has, in fact, escalated the policies and practices with the specific intention of permanently precluding the exercise of the right of Palestinian people, including their right to independence and in their state. It is very apparent and evident that the General Assembly considered the Israeli military occupation as illegal, and Security Council the overriding necessity to the prolonged occupation when the occupation was in its early years. There is no doubt that it is unlawful, is even more apparent of the flagrant now that has come to the 6 decades. As consequences of Israeli prolonged 6-decade occupation of the OPT is a clear violation of premonitory norms of the general international law, derogation from which is not permitted. The occupation itself must be regarded as illegal with all relevant legal consequences that attach under the law and international responsibility. This means that it must brought to an immediate and unconditional end and total end. Mr. President, distinguished justice, what we mentioned is also means that the Palestinian people has the right to resist the occupation by all means, and it is a moral and legal obligation upon all states to assist and support the Palestinians in their legitimate struggle for liberty and independence. Now, Mr. President, members of the court, come to the consequences. We start by legal consequences on the occupying power. It must fulfill the occupying power, or Israel must fulfill its obligation to respect the Palestinian people's right to self-determination. Israel must immediately end the violation of the international obligation to respect the right of the Palestinian people to self-determination by ceasing all acts and measures that prevent and impede the Palestinian people from exercising their right to self-determination, including the immediate cessation of the occupation in all its manifestations. The obligation of the state responsible for an act contrary to the international law in general and international law. Accordingly, Israel is obligated to immediately cease of violation of the legal obligation in Jerusalem and the occupied Palestinian territories as a whole. The cessation of this violation includes, inter alia, the dismantling of the illegal structure, including the settlements and the wall. Israel shall be obligated to make restitution and compensation for the damage suffered by the Palestinian people, and Israel obligated to immediately repeal all these laws that aims to racial segregation and discrimination enshrining in the apartheid regime imposed against the Palestinian people. The other consequences, the legal consequences for the third parties or for the third states. Given the orga omnis nature of the right to self-determination in accordance with the standing resolution of the United Nations General Assembly, it is also incumbent on all states to ensure that any impediment to the exercise of the right of self-determination by the Palestinian people is brought to an immediate end. In view of the nature and importance of the rights and obligation involved, all states have an obligation not to recognize the illegal situation resulting from Israeli violation in the occupied Palestinian territories, including Jerusalem. They are also obliged not to provide aid or assistance in maintaining the situation created by these illegal acts. Furthermore, the states parties to the Fourth Geneva Convention are obliged to ensure that Israel complies with the international humanitarian law as enshrined in that convention, including the forcible transfer of Palestinians and the transfer of Israeli citizens in the occupied Palestinian territory. Also, there is a legal consequences on the UN and all the United Nations. The United Nations, and in particular General Assembly and the Security Council, should consider what further measures are necessary to remove without delay any obstacle of the realization of the Palestinian people's right to self-determination, and to take necessary measures to ensure the implementation of its relevant resolution without further delay. Then also the United Nations should consider that further action required to bring illegal occupation, ensure the implementation of the relevant resolution without further delay. Mr. President, distinguished judges, lately we have the Libyan state submission. I will, with your permission, I will give the floor to my colleague, Dr. Nasser Al-Ghita.
I thank Professor Al-Gihani, and I'll give the floor to Mr. Nasser Al-Ghita. You have the floor, sir.
Mr. President, members of the court, it is my honor to appear before you today on behalf of the state of Libya. And with your permission, I will proceed to the final points of our presentation today, which is the submissions to the court. We submit to the court that the court has jurisdiction to deliver the advisory opinion requested by the General Assembly, as there are no grounds for declining to exercise its jurisdiction. We believe that Israel is responsible for serious breaches of obligations arising under peremptory norms of international law, including but not limited to the illegality of the admissibility of the acquisition of territories through the use of force, and the prohibition of aggression, the prohibition against racial discrimination and apartheid, and the right of the Palestinian people to self-determination. The occupying power is obliged to immediately, unconditionally, and completely end its occupation and withdraw from the OPT. This entails, inter alia, revoking all legislation and measures aimed at the annexation of Jerusalem and the rest of the OPT. End of aggression, and blockade on Gaza, withdrawal of all occupation forces, and dismantling of its illegal settlements and their associated regimes. To revoke all of its discriminatory legislations, measures against the Palestinian people, and to respect the unalienable rights of Palestinian people to self-determination and the Palestinian refugees to return to their home. To provide assurance and guarantees of non-repetition of the above-mentioned violations. To make full reparation for injuries caused by the policies and practices vis-à-vis the state of Palestine and the people of Palestine, as a result of the internationally wrongful act or actions. All states and international organizations, including the United Nations, are obliged not to recognize the illegal situations resulting from the international wrongful act of the occupying power, not to contribute to the violations of the right of the Palestinian people, and by not rendering aid or assistance in any way to the occupying power, to cooperate to protect the right of Palestinian people and to end the occupying power's violations of those rights, by enabling the Palestinian people to exercise their right to self-determination, and by holding accountable those responsible for crimes related to the colonization of the West Bank, including East Jerusalem, the unlawful annexation of the OPT, and the blockade and the current aggression on Gaza. And more generally, the violations of the fundamental rights of the Palestinian people as a whole, including the right to self-determination and to be free from racial discrimination and apartheid, as well as the right of Palestinian people to life and liberty. I would like also to stress that our observation before the court today has no legal effect in relation to the recognition of Israel. Mr. President, members of the court, this brings our presentation today to the end, and I thank you and your member of the court for your kind attention. Thank you.
I thank the delegation of Libya for its presentation. Before I invite the next delegation to make its oral statement, the court will observe a break for 10 minutes. The sitting is suspended. Please be seated. The sitting is resumed. J'invite maintenant la délégation de l'État participant suivant, le Luxembourg, à prendre la parole devant la Cour et appelle M. Alain Guermont à la barre. Vous avez la parole, monsieur.
Monsieur le Président, Mesdames et Messieurs les membres de la Cour, c'est un honneur pour moi de présenter devant vous aujourd'hui, en tant qu'agent du gouvernement du Luxembourg, nos observations orales dans le cadre de la présente requête pour avis consultatif. Le Luxembourg a le plus grand respect pour la Cour et pour le système de justice internationale dans lequel elle exerce ses fonctions. La participation du Luxembourg dans le cadre de la présente requête reflète sa volonté de contribuer au renforcement de l'ordre international fondée sur la règle de droit, pour laquelle la Cour avait un rôle essentiel. Le Luxembourg a voté en faveur de la résolution 77-247 de l'Assemblée générale et espère que l'avis consultatif de la Cour pourra renforcer le rôle des Nations unies pour contribuer à la réalisation d'une solution pacifique du conflit israélo-palestinien dans le respect du droit international. Mon pays soutient pleinement la vision formulée par le Conseil de sécurité d'une région où deux États démocratiques, Israël et la Palestine, vivent côté à côté en paix à l'intérieur de frontières sûres et reconnues. En tant qu'État membre de l'Union européenne, le Luxembourg souscrit aux positions agréées de l'Union sur le processus de paix au Proche-Orient, telles que notamment reflétées dans les conclusions du Conseil de l'Union européenne ainsi que les déclarations de l'Union. En ce qui concerne la recevabilité de la demande, le Luxembourg renvoie à son exposé écrit du 20 juillet 2023. Il estime que la Cour est compétente pour répondre à la requête et qu'il n'existe pas de raison décisive justifiant un refus de la Cour d'émettre un avis consultatif sous son pouvoir discrétionnaire en vertu de l'article 65 du statut de la Cour. Quant au fond de la requête, le Luxembourg souhaite présenter 4 observations sur les points juridiques soulevés dans les questions soumises à votre Cour, à savoir le droit applicable, le droit du peuple palestinien à l'autodétermination, l'occupation, la colonisation et l'annexion des territoires palestiniens, ainsi que les conséquences juridiques qui en découlent pour Israël et les autres États. Premièrement, en ce qui concerne le droit applicable, votre Cour avait déjà procédé à une détermination dans son avis du 9 juillet 2004 sur les conséquences juridiques de l'édification d'un mur dans le territoire palestinien occupé. J'en rappellerai les éléments de droit applicables dans le cadre de la présente requête. Les principes énoncés dans la Charte des Nations unies au sujet de l'usage de la force, lesquels reflètent le droit international coutumier et comme corollaire l'illicéité de toute acquisition de territoire résultant de la menace ou de l'emploi de la force. Le principe du droit des peuples à disposer d'eux-mêmes, tel qu'il a été consacré par la Charte, la résolution 2625 de l'Assemblée générale et les 2 pactes sur les droits humains de 1966. Les règles et principes du droit international humanitaire, tels qu'ils découlent des dispositions du règlement de la Haye de 1907, qui ont valeur coutumière, et de la 4e Convention de Genève, et le droit international des droits humains. Sont encore pertinents les résolutions spécifiques du Conseil de sécurité relatives au territoire palestinien occupé et aux droits du peuple palestinien, celle de l'Assemblée générale, pour autant qu'elle reflète le droit international coutumier, ainsi que la déclaration de principe sur les arrangements intérimaires d'autonomie du 13 septembre 1993 et, enfin, l'accord intérimaire israélo-palestinien sur la Cisjordanie et la bande de Gaza du 28 septembre 1995, appelé accord d'Oslo II. À cela viennent s'ajouter, depuis 2012, les instruments juridiques multilatéraux auxquels la Palestine est devenue partie et qui, par leur objet, entrent dans le cadre de la présente analyse. Ma deuxième observation concerne le droit à l'autodétermination. Ce droit est explicitement mentionné dans les articles 1er et 55 de la Charte. Selon l'article 1er, deuxième paragraphe de la Charte, Un des buts des Nations Unies est de développer entre les nations des relations amicales fondées sur le respect du principe de l'égalité des peuples et de leur droit à disposer d'eux-mêmes et prendre toute autre mesure propre à consolider la paix dans le monde. Plus particulièrement, le droit à l'autodétermination a été régulièrement reconnu par différents organes des Nations Unies. Il a été précisé dans la résolution 2625 de l'Assemblée générale, qui indique que tout État a le devoir de favoriser la réalisation du droit des peuples à disposer d'eux-mêmes, conformément aux dispositions de la Charte. Le Conseil de sécurité a également évoqué la nécessité d'un règlement juste et durable du conflit israélo-palestinien qui tienne compte des, je cite, droits politiques légitimes du peuple palestinien. Votre Cour a souligné dans l'avis consultatif de 2004 que l'existence d'un peuple palestinien ne saurait plus faire débat et indiqué que le droit à l'autodétermination figure parmi les droits légitimes du peuple palestinien mentionnés dans l'accord Oslo II, en confirmant que ce droit constitue une obligation erga omnes. Dans l'avis sur les effets juridiques de la séparation de l'archipel des Chagos de Maurice, votre Cour a reconnu que le droit à l'autodétermination est un droit humain fondamental, revêtant le caractère de norme coutumière. Elle a encore précisé que le droit à l'autodétermination doit être l'expression de la volonté libre et authentique du peuple concerné, même si, en droit international coutumier, il n'impose pas un mécanisme particulier pour sa mise en œuvre dans tous les cas. Concernant les territoires palestiniens occupés, le développement de colonies de peuplement et le morcellement qui en découle portent gravement atteinte au droit à l'autodétermination du peuple palestinien et entravent de ce fait l'édification d'un État de Palestine viable dont la perspective s'éloigne au fur et à mesure que les atteintes à l'intégrité du territoire palestinien persistent et augmentent. En lien avec le droit du peuple palestinien à l'autodétermination, l'Assemblée générale et le Conseil de sécurité ont ainsi affirmé l'illégalité des implantations israéliennes et exigé d'Israël de mettre fin, entre autres, à ces activités d'implantation qui ont toutes des conséquences graves et préjudiciables, entre autres pour les droits humains du peuple palestinien, notamment son droit à l'autodétermination. Selon le droit de la responsabilité internationale, la violation de ce droit constitue un fait internationalement illicite ayant un caractère continu. Au terme des articles sur la responsabilité de l'État pour faits internationalement illicites adoptés par la Commission du droit international en 2001, l'État responsable conserve le devoir d'exécuter l'obligation violée si celle-ci est encore en vigueur, ce qui est à l'évidence le cas ici. Il a aussi pour obligation de mettre fin aux faits internationalement illicites. Ce devoir s'impose d'autant plus que la réalisation du droit à l'autodétermination est une condition essentielle à la garantie et au respect effectif des droits humains, ainsi qu'à la préservation et à la promotion de ces droits. J'aborderai à présent ma troisième observation concernant l'occupation, la colonisation et l'annexion des territoires palestiniens. L'occupation est une situation de fait objective qui se caractérise par le contrôle effectif exercé par un État sur un territoire déterminé. Le régime juridique de l'occupation s'applique indépendamment de la licéité de l'opération ayant permis à l'État d'exercer son contrôle effectif sur le territoire occupé. De très nombreuses résolutions du Conseil de sécurité utilisent les expressions « territoire occupé » ou « territoire palestinien occupé », à commencer par la résolution 242 de 1967. Le Conseil et l'Assemblée générale ont eu l'occasion de rappeler à Israël ses obligations dans ce cadre en l'appelant, en tant que puissance occupante, à s'acquitter des obligations juridiques et des responsabilités qui lui incombent en vertu de la 4e Convention de Genève, qui est applicable à tous les territoires occupés par Israël depuis 1967. Les règles du droit de l'occupation repose sur l'idée selon laquelle l'occupation n'est qu'une situation temporaire. Elle se fonde sur les principes que la puissance occupante n'acquiert pas la souveraineté sur le territoire qu'elle occupe et qu'elle doit s'abstenir de prendre des mesures qui pourraient entraîner des changements permanents, en particulier sur le plan social, économique et démographique. Elle doit également maintenir la sécurité et l'ordre public dans le territoire occupé et administrer ce dernier de sorte à assurer la protection et le bien-être des personnes protégées, c'est-à-dire ne pas exercer son autorité aux fins de servir ses propres intérêts. Le statut d'occupation militaire impose donc des obligations positives, dont la principale est la protection des populations soumises à cette occupation. L'applicabilité simultanée du droit international des droits humains et du droit international humanitaire dans une situation de conflit armé ou d'occupation a également été confirmée à de nombreuses reprises, y compris par votre Cour. Il a ainsi été établi que le champ d'application du droit international des droits humains ne dépend pas seulement des limites territoriales d'un État, mais aussi de l'exercice de sa compétence ou de son contrôle effectif, même s'il n'est pas situé sur le territoire souverain de cet État. Le droit international des droits humains est ainsi applicable à l'ensemble du territoire palestinien occupé, au vu du contrôle effectif et de la compétence territoriale exercée par Israël en tant que puissance occupante. Israël est donc lié par l'obligation de respecter et protéger les droits humains de la population. Ces obligations complètent et renforcent celles découlant du droit de l'occupation en vertu du droit international humanitaire. Israël a évidemment le droit de se protéger et de protéger son peuple contre les attaques. Toute mesure prise dans l'exercice de ce droit doit cependant respecter les règles pertinentes du droit international. En conséquence, Israël, en tant que puissance occupante et non souveraine du territoire palestinien, doit veiller à ce que, pendant toute la durée de son occupation, son administration de ce territoire soit conforme aux obligations qui lui incombent en vertu du droit international humanitaire et des droits humains. La Cour avait constaté dans son avis de 2004 qu'Israël avait violé divers droits humains des Palestiniens. Ces violations semblent s'être poursuivies en raison de l'expansion rapide des colonies et des infrastructures associées. Par sa pratique d'établissement et d'extension des colonies, Israël s'est engagé dans un transfert d'une partie de sa propre population civile vers le territoire palestinien occupé en violation de l'article 49, paragraphe 6 de la 4e Convention de Genève. Ceci a eu lieu malgré les condamnations expresses et répétées de cette pratique et les appels à y mettre fin par le Conseil de sécurité et l'Assemblée générale, et nonobstant la confirmation par votre Cour de l'illégalité de cette pratique dans son avis de 2004. La Cour a également constaté qu'Israël avait détruit et s'était approprié des biens palestiniens d'une manière injustifiable par les nécessités militaires et dans le cadre d'un conflit armé, et qu'il s'agissait d'une violation des articles 46 et 52 du règlement de la Haye et de l'article 53 de la 4e Convention de Genève. Or, des rapports récents du secrétaire général des Nations Unies et du haut-commissaire des Nations Unies aux droits de l'homme démontrent qu'Israël a continué à détruire et s'approprier illégalement des biens dans l'ensemble du territoire palestinien occupé dans le cadre de son encouragement et de sa facilitation de l'expansion des colonies de peuplement. Ces rapports démontrent également que les Palestiniens sont de plus en plus victimes de violences de la part des colons israéliens et qu'ils ne bénéficient pas d'une protection adéquate contre ces violences de la part des forces de sécurité. Le secrétaire général et le haut-commissaire ont tous les deux conclu qu'Israël n'a donc pas protégé la population palestinienne conformément aux obligations qui lui incombent en vertu de l'article 43 du règlement de la Haye et de l'article 27 de la 4e Convention de Genève. Ils ont signalé que ces violences, accompagnées de l'appropriation et la destruction de biens palestiniens, ont dans certains cas contraint les Palestiniens à quitter leur lieu de résidence, ce qui fait craindre un transfert forcé en violation de l'article 49, paragraphe 1er de la 4e Convention de Genève. Les mesures prises par Israël dans le territoire palestinien occupé entraînent des changements fondamentaux, notamment démographiques, pouvant endosser un caractère permanent. Elles affectent négativement la population palestinienne au lieu de lui être bénéfiques et contribuent à la création d'un environnement coercitif. Elles vont donc à l'encontre des principes du droit de l'occupation. La communauté internationale partage une préoccupation croissante à l'égard des activités de colonisation israélienne dans le territoire palestinien occupé, qui constitue une pratique préjudiciable à la réalisation de l'objectif de la solution des deux États. Votre Cour avait conclu dans l'avis de 2004 que les colonies de peuplement installées par Israël dans le territoire palestinien occupé l'ont été en méconnaissance du droit international. Le Conseil de sécurité a dénoncé cette situation à plusieurs reprises. Dans sa résolution 2334, le Conseil a réaffirmé sa détermination que l'établissement de ces colonies constitue une menace pour la paix et la sécurité internationale, une violation flagrante du droit international et un obstacle majeur à la réalisation de la solution des deux États et d'une paix juste, durable et globale, et a réitéré sa demande qu'Israël cesse immédiatement et complètement toute activité de colonisation. Les activités de colonisation ne sauraient non plus être justifiées par d'autres fins. Alors qu'Israël est confronté à une attaque armée lui permettant d'exercer son droit à la légitime défense, ces activités de colonisation ne peuvent cependant pas être justifiées au titre de ce droit, en ce qu'elles ne constitueraient pas, en tout état de cause, une mesure nécessaire ou proportionnée, comme l'exige le droit international pour toute mesure prise dans l'exercice du droit à la légitime défense. L'illicéité de cette activité ne peut pas non plus être exclue par un état de nécessité en vertu du droit international coutumier, tel que reflété dans l'article 25 des articles de la Commission du droit international de 2001, notamment parce qu'elle n'est manifestement pas le seul moyen pour Israël de sauvegarder un intérêt essentiel contre un péril grave et imminent. Ce constat d'illicéité demeure aujourd'hui d'autant plus fondé que, depuis 2004, Israël a poursuivi et accentué sa politique d'implantation de colonies en territoire palestinien occupé, contraire à ses obligations au regard du droit international. Comme votre Cour l'avait indiqué dans le cadre de la construction d'un mur, une telle situation peut amener à un fait accompli et à un processus d'annexion de facto. Or, un des principes fondamentaux du droit international est la prohibition de ce type d'annexion. Comme il ressort notamment de la résolution 2625 de l'Assemblée générale, nulle acquisition territoriale obtenue par la menace ou l'emploi de la force ne sera reconnue comme légale. Le développement des colonies compromet ainsi la viabilité d'un futur État palestinien d'un seul tenant et donc la perspective de parvenir à une solution négociée de deux États. Monsieur le Président, permettez-moi d'en venir à ma quatrième et dernière observation. J'aborderai en premier lieu les conséquences juridiques qui en découlent pour Israël, suivies de celles qui en découlent pour les autres États. Votre Cour a estimé dans l'avis de 2004 qu'Israël était tenu de mettre fin aux violations de ses obligations juridiques, y compris ses obligations au titre du droit international humanitaire et son obligation de respecter le droit du peuple palestinien à l'autodétermination et de réparer les dommages causés par ces violations. L'examen de la situation actuelle fait apparaître des violations continues du droit international auxquelles Israël doit mettre un terme. Elle porte sur le droit des peuples à disposer d'eux-mêmes, dont le caractère coutumier est établi, et sur les règles actuellement en vigueur du droit international humanitaire et du droit international des droits humains applicables à la situation dans les territoires palestiniens occupés. La conséquence juridique première résultant de la responsabilité est la cessation du fait illicite. Selon les termes de l'article 30, sous lettre A des articles de la Commission du droit international de 2001, l'État responsable d'un fait illicite a l'obligation d'y mettre fin si ce fait continue. Les deux conditions en sont, premièrement, le caractère continu de l'acte illicite et, deuxièmement, le fait que la règle violée soit toujours en vigueur. De ce fait, dans le cadre de la présente procédure, l'obligation de cessation implique que les politiques et pratiques identifiées comme violant le droit international, en particulier les activités de colonisation, prennent fin et que soient abrogés les actes juridiques internes sur lesquels elles sont fondées. Je rappellerai le paragraphe 4 de la résolution 2334 du Conseil de sécurité qui souligne, et je cite, qu'il est essentiel qu'Israël mette un terme à toutes ses activités de peuplement pour préserver la solution des deux États et demande l'adoption immédiate de mesures énergétiques afin d'inverser les tendances négatives sur le terrain qui mettent en péril la solution des deux États. En ce qui concerne les violations du droit international humanitaire et du droit international des droits humains commises dans le territoire palestinien occupé, il conviendrait également qu'Israël procède à la recherche et la divulgation des faits et mène des enquêtes pour identifier et poursuivre les personnes responsables. Au sujet des autres États, il convient de rappeler que toutes les hautes parties contractantes aux conventions de Genève ont l'obligation de respecter et de faire respecter le droit international humanitaire. Ensuite, dans l'avis de 2004, votre Cour estimait qu'Israël avait manqué à son obligation de respecter le droit du peuple palestinien à l'autodétermination et à certaines de ses obligations en matière de droit international humanitaire. Elle a conclu que tous les États ont l'obligation de ne pas reconnaître la situation illégale et qu'ils ont l'obligation de respecter les droits de l'homme et celle de respecter le droit à l'autodétermination. Il en résulte une obligation pour les États à ne pas reconnaître comme légale une situation contraire au droit international, soit formellement, soit par des actes qui impliqueraient une telle reconnaissance. Aucune forme d'annexion, y compris partielle, ne saurait ainsi être reconnue au regard du droit international. L'Assemblée générale et le Conseil de sécurité ont tout autant appelé à la non-reconnaissance des situations créées par l'annexion ou le déni du droit à l'autodétermination. Les États sont donc tenus de coopérer pour mettre fin à toutes les violations, y compris de manière collective. Cela englobe le rôle du Conseil de sécurité et de l'Assemblée générale des Nations unies, ainsi que, le cas échéant, d'autres organisations internationales, dont notamment l'Union européenne. Enfin, le respect du statut international des territoires palestiniens occupés entraîne encore des effets sur le plan économique. Je rappellerai que, dans sa résolution 2334, le Conseil de sécurité a demandé à tous les États de faire une distinction dans leurs échanges en la matière entre le territoire de l'État d'Israël et les territoires occupés depuis 1967. Cela se traduit en droit de l'Union européenne par la prise en compte du droit international et de l'avis de votre Cour de 2004 en traitant de manière différenciée les produits en fonction de leur origine. Monsieur le Président, permettez-moi de faire quelques remarques finales. La Cour avait demandé en 2004 à l'Organisation des Nations Unies dans son ensemble de redoubler d'efforts pour mettre rapidement un terme au conflit israélo-palestinien afin d'établir une paix juste et durable dans la région. Cette demande reste plus que jamais pertinente. Elle fait écho à l'obligation pesant sur Israël et sur la Palestine au titre de la Charte des Nations Unies et du droit international coutumier de résoudre pacifiquement leurs différends en s'engageant dans la voie de négociation de paix et en mettant en œuvre les résolutions pertinentes des Nations Unies. Israël a des préoccupations légitimes de sécurité et à ce titre dispose d'une marge d'appréciation importante dans le choix et la mise en œuvre des moyens requis. Cependant, Ces actes, au nom de la légitime défense ou de la sécurité nationale, doivent respecter le droit international, notamment le droit international humanitaire et les droits humains. Le respect est essentiel pour améliorer la condition humanitaire des personnes en situation d'occupation et pour réaliser une paix juste et durable. Monsieur le Président, Mesdames et Messieurs les membres de la Cour, ceci conclut mon intervention. Je vous remercie de votre aimable attention.
Je remercie la délégation du Luxembourg pour son exposé. I invite now the next participating delegation, Malaysia, to address the court and call upon His Excellency, Mr. Dato Seri Utama Haji Muhammad Haji Hassan, to take the floor.
Bismillahirrahmanirrahim. Mr. President, distinguished members of the court. It is a great honor and privilege for me to represent Malaysia in this advisory proceeding concerning the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory, including East Jerusalem. As I stand here today, Gaza is facing devastation, including in Rafah at the southern end of the Strip. The West Bank is also at risk. Safeguarding Palestinians from destruction is crucial, especially in light of Israel's non-compliance with the recent order of the provisional measures of this court on 26 January 2024 in the case brought by South Africa. The matter before you today is of grave concern to the General Assembly, all states, and the Palestinian people. The Palestinian people have long suffered dehumanization, demonization, brutal collective punishment. They have endured and are still enduring the denial of their right to self-determination due to the policies and practices of Israel in the OPT. It is incumbent upon each of us to do our part in ending their decades of long suffering and to work towards peace in their land. Malaysia has consistently supported peace for the Palestinian people, aligning itself with 11 General Assembly and Security Council resolutions, as was the case in the advisory opinion on the wall. This court is uniquely positioned to give authoritative guidance on the legal questions submitted by the General Assembly. With a firm belief in this court's role as the custodian of the international law, we remain confident that justice and peace will prevail for Palestinians. Malaysia's submission today is straightforward. The policies and practices of Israel in the OPT are a set of acts and measures that individually breach a number of rules of public international law. These policies and practices, however, taken together, also amount to serious breach of right to self-determination of the Palestinian people, which is protected by peremptory norm of international law. The occupation of Palestine for its part is nothing but these policies and practices itself. The occupation itself is thus in serious breach of peremptory norm of international law and must be brought to an end immediately. In my presentation, I will first deal briefly with the court jurisdiction and its discretion to respond to the request of the General Assembly. The second part of my presentation summarizes Malaysia's position on the legality of the policies and practices of Israel in the OPT. In the third and final part, I will set out the legal consequences that arise for Israel, for all other states, and for the United Nations, respectively, from what Malaysia submit as a flagrant denial of Palestinian people's right to self-determination. Mr. President, members of the court, as regards the court's jurisdiction to render this advisory opinion, Malaysia considers that the requirement of Article 65, paragraph 1 of the Statute of the Court, read together with Article 96, paragraph 1 of the Charter of the United Nations, are plainly satisfied in the present case. First, the General Assembly is competent to request an advisory opinion, given that the United Nations has a permanent responsibility towards the question of Palestine until the question is resolved in all its aspects in satisfactory manner in accordance with international legitimacy. Second, the question addressed to the court are legal questions framed in terms of law and raising problems of international law. The request that the court determine the existence of violence of international law and their corresponding legal consequences is by its very nature susceptible to a reply based on law. Malaysia further submits that there are no compelling reasons preventing the court from exercising its jurisdiction, which after all represent the court's own words, its participation in the activities of the United Nations, which in principle should not be refused. Israel and others have argued that the court is being asked to resolve what is essentially a bilateral dispute between Israel and Palestine and to make permanent status determinations. Israel, in its unsurprisingly brief written statement, argues that both interested parties have given their express and binding consent to resolve all relevant disputes through another settlement means, namely through direct dialogue. Malaysia stresses first and in principle that questions of self-determination are never purely bilateral matters between states. They refer to a peremptory norms of international law, which produces erga omnes obligations owed to the international community as a whole. That being so, all states and the United Nations have a legal interest in the protection of the rights involved. But quite apart from that, the questions before the court are not at all concerned with settling disputes between Israel and Palestine. The court is requested to set out the legal consequences of Israel's policy and practices in the OPT. Its advisory opinion will inform the exercise by General Assembly of the permanent responsibility of the United Nations towards question of Palestine. Such matters neither involve the determination of permanent status issue, nor are they for the parties to any direct dialogue to waive or disregard. As a final point, Malaysia recalls that it was on this ground that the court decided to exercise its advisory jurisdiction in the world, rejecting these and other arguments which have been replayed in this proceeding, such as the court does not have sufficient information and evidence. Malaysia admits that the court was correct then, and that there are no more compelling reasons today for the court to refuse to render the opinion requested than there were 20 years ago. Mr. President, members of the court, the objective of Malaysia in making these oral submissions is not only to make its position known on the legal question before the court. Its objective is also to assist the court in its important work. With that in mind, Malaysia offers here a way of thinking about the substance of the request of the General Assembly. The General Assembly, Mr. President, refers its request to the right to the self-determination in particular, in question A, to the prolonged occupation, settlement, and annexation of the occupied Palestinian territory, to the measures aimed at altering the demographic composition character and status of the holy city of Jerusalem, and to the adoption of discriminatory legislation and measures. And in question B, then, the Assembly refers to the policies and practices of Israel referred to in question A and asks the court how this affects the legal status on the occupation and what the corresponding legal consequences are. Malaysia submits that the policies and practices of Israel in the OPT consist of a set of an acts and of legislative, administrative, and other measures. These include the construction, maintenance, and extension of a wall in the OPT, the establishment, maintenance, expansion, and protection of settlement in the OPT, along with the associated discriminatory legal regime, the demolition of Palestinian homes, and the forced transfer of the Palestinians in that territory, the control and the provision of food, water, electricity, and other amenities to the OPT, and other acts and measures, detailed both by United Nations organs and by the states having chosen to appear before you. All these policies and practices constitute in and of themselves violation of individual rules of international law, including international humanitarian law and the law of occupation, international human rights law, the prohibition of the use of force, and the associated prohibition of acquisition of territory by the threat or use of force, and others. All of this is detailed in Malaysia's written statement, as well as in other written statements submitted to the court in these proceedings. And we have heard over the last few days many states argue before the court along these lines. Malaysia submits that, taken together, these policies and practices, apart from breaching individual rules of international law, also constitute a serious breach of the Palestinian people's right to self-determination, a jus cogens obligation incumbent on all states and owed to the international community as a whole. Malaysia further submits that these policies and practices and in and of themselves constitute the occupation of the Palestinian territory. These policies and practices, Mr. President, is nothing but the means by which Israel is exercising its control over the OPT, the means by which it is enforcing its occupations. These policies and practices resulting as they do in a serious breach of the jus cogens right to self-determination cannot but affect the legal status of the occupation of the Palestinian territory by Israel, rendering it unlawful. Mr. President, allow me now to put some flesh on the bones of the argument that I have just presented. First, there can be no doubt that the right to self-determination is a peremptory norm of international law, from which flow obligation erga omnes. This court has already confirmed as much on numerous occasions. It has done so both explicitly with respect to the erga omnes character of the relevant obligations and by drawing the consequences of a serious breach of the right to self-determination in a manner that reflects the special consequences that accrue to a serious breach of peremptory norms of international law. Second, there can also be no doubt that the right to self-determination applies to the Palestinian people. As this court noted in the World Advisory Opinion, as regards to the principle of the right of people to self-determination, the existence of Palestinian peoples is no longer an issue. Third, Malaysia submits that there are 4 core substantive elements of the right to self-determination. The first such element is the right of a people to territorial integrity. As this court confirmed in HAGUE, The right to territorial integrity of a non-self-governing territory is a corollary of the right to self-determination. The second element is the right of the people to territorial unity and the protection of its integrity as a people. As this court found in the World Advisory Opinion, alterations of the demographic composition of the occupied Palestinian territory constitute a violation of the right to self-determination. Third, the people has a right to permanent sovereignty over its natural wealth and resources as part of its right to self-determination. The General Assembly has described such permanent sovereignty as a basic constituent of the right to self-determination and has further declared that a violation of the rights of people to sovereignty over their natural wealth and resources is contrary to the spirit and principle of the United Nations Charter. Finally, the fourth element of the right to self-determination is the freedom of people to pursue their economic, social, and cultural development. According to the General Assembly, this is a fundamental aspect of the principle of equal rights and self-determination of peoples as enshrined in the United Nations Charter. The fourth submission that Malaysia wishes to make is that the policies and practices of Israel in the OPT violate numerous individual rules of international law, as well as each one of the four core substantive elements of right to self-determination. I will demonstrate this as briefly as possible, Mr. President. Israel's policies and practices with respect to the legal status of East Jerusalem, along with its establishment, facilitation, and expansion of settlements in the OPT with their associated infrastructure and discriminatory legal regime amount to attempts to de jure and de facto annexation respectively. This is in clear breach of provision of acquisition of territory by the threat or use of force, a corollary of the provision of the use of force in the United Nations Charter, which is a peremptory norms of international law. Israel's transfer of civilians into the OPT is a breach of Article 49, paragraph 6 of the Fourth Geneva Convention in 1949 and constitutes a war crime per the Rome Statute in the International Criminal Court. Apart from constituting individual breaches of international law, these policies and practices violate the territorial integrity of the Palestinian people and thus the right to self-determination. Israel policy and practices which aim at changing the demographic composition of the OPT, along with the creation of enclaves of Palestinians, the demolition of their homes, the limitation of their freedom of movement, including the blockade, seize, and perpetual evacuation of the Gaza Strip, constitute violations of international humanitarian law and the international human rights law. But they also violate the unity and integrity of the Palestinian people and thus its right to self-determination. Israel policies and practices of expropriation of Palestinian land for use as settlements, of control over all water resources in the West Bank, and control of water provision in the Gaza Strip, of granting licenses for oil and gas extraction, and of operating quarries in the OPT constitute violations of international humanitarian law and of international human rights law. But they also violate the permanent sovereignty of the Palestinian people over its natural wealth and resources. They thus violate its right to self-determination. Israel's policies and practices of exploitation of natural resources, of restrictive zoning and planning regime in the OPT, of blockading Gaza and subsequently razing it to the ground, of hampering, of limiting access of Palestinians to health services, educational establishments, and primary sources of water, of preventing Palestinians from accessing sites of religious and cultural importance in the OPT, of restricting their freedom of association and expression, and of condoning settler violence, constitute violence of international law and the international human rights law. But they also violate the Palestinian people's freedom to pursue the economic, social, and cultural development, and thus its right to self-determination. Mr. President, 20 years ago, exactly 20 years ago, almost to the day, Malaysia argued before this court the Israel construction of a wall deep inside the OPT violated the Palestinian people's right to self-determination. And this court found in its advisory opinion that construction, along with measures taken previously, severely impedes the exercise by the Palestinian people of its right to self-determination, and it is therefore a breach of Israel's obligation to respect that right. Along with these measures taken previously, the court said, that was a reference, as is evident from the preceding paragraph of the advisory opinion, to the policies and practice of Israel involving the establishment of settlements and their associated regime. If that was the case then, 20 years ago, a theory that this must be now case, a theory that must be the case now, how could it not be? If anything, Israel has maintained and extended the wall, and it has escalated the measures taken previously and ramping up the establishment of the settlement, expanding them, providing funding and amenities to them, as well as security, and extending the associated discriminatory legal regime. It has also continued and escalated the demolition of Palestinian homes, the practice of forced transfers, and the transfers of its own civilians into the OPT. Even in 2004, based on conduct less grievous than the one before the court today, Israel's breach of the right to self-determination of the Palestinian people was found to constitute a serious breach of a peremptory norm of international law. Reading the relevant paragraphs of the court's opinion leave no room for doubt in this respect. The court called upon all states not to recognize the illegal situation resulting from the construction of the wall in the OPT and not to render aid or assistance in maintaining the situation created by such construction. The court also found that it is for all states to see to it and that any impediment resulting from the construction of the wall, the exercise by Palestinian people of its right to self-determination is brought to an end. This language closely reflects the Article 41 of the Articles of State Responsibility regarding the particular consequences of serious breaches of obligations under peremptory norm of international law. The theory argument I made with respect to the existence of violation of the right to self-determination applies here as well. This is not just any violation, Mr. President. It is a serious breach of peremptory norm of international law. It is, if it were so, with respect to the much more limited issue before the court in 2004, it must be certainly to be today. We are no longer talking about the construction of wall. We are talking about the whole host of policies and practices of the acts and measures so well documented by the United Nations and by most of the states that have spoken in these proceedings. This could not amount to anything less than what the construction of a wall amounted to 20 years ago. Indeed, They underscore the devastating deterioration of situation in the occupied Palestinian territory since then. Mr. President, members of the court, I will have to return to the legal consequences of Israel's policies and practices in the OPT in the final part of my presentation. But before I do so, I would like to conclude this part of the argument. I have established so far that Israel's policies and practices in the OPT constitute not only violation of several rules of international law, but also violation of each core element of the right to self-determination of the Palestinian people. Malaysia submits that the serious breach of a most fundamental peremptory norm of international law renders unlawful the occupation as a whole. In particular, Malaysia submits that it is the policies and practices discussed and assessed in this proceeding that constitute the occupation. These policies and practices are, in fact, the occupation itself. There are many means by which Israel enforces its control, the means by which it occupies the Palestinian territory. And they are also unlawful. They breach a great number of rules of international law and ultimately result in a serious breach of the Palestinian people's right to self-determination. This must mean that the occupation as a whole is unlawful, as it constitutes as a flagrant denial of right to self-determination. Mr. President, members of the court, I turn now to the final part of my presentation, which concerns the legal consequences arising for Israel, for all other states, and for the United Nations, respectively, out of the serious breach of the obligation to respect the self-determination of the Palestinian people. As regards the legal consequences for Israel arising from this serious breach, I will be brief. Israel must first of all cease the continuing violation. This means that it must cease all the relevant policies and practices I have already discussed. Consequently, it must withdraw immediately from the occupied Palestinian territory. Second, Israel offers assurance and guarantees of non-repetition. And third, Israel is under obligation to offer full reparation. This means that it must provide both actual and juridical restitution, including the annulment of repeal of all offending legislative and regulatory measures it has adopted for the OPT. Israel must also offer compensation for all material and moral damage caused by the breach of the right to the self-determination, to the extent that this is not made good by restitution. The legal consequences arising for Israel from its serious breach of the right to self-determination are, in principle, no more burdensome than the legal consequences arising for any state that has committed even a trivial breach of international law. Malaysia stresses the obligation. It is rather for other states, indeed, for all other states, that special legal consequences arise out of this serious breach of just cogence. It is for this reason that Malaysia felt it was under a duty to participate in this advisory proceeding. In particular, all states must cooperate to bring to an end, through lawful means, the serious breach of the right to self-determination and consequently the unlawful occupation of the Palestinian territory. Further, all states must not recognize as lawful the situation created by the serious breach of the right to self-determination, that is, the occupation of the Palestinian territory. Finally, all states must not render its or assistance to Israel in maintaining the unlawful denial of the Palestinians' right to self-determination, thus the occupation of the Palestinian territory. Malaysia stresses the obligation of all states to support UNRWA and to halt any financial or military support to Israel that aids and assists in the denial of the right to self-determination and the unlawful occupation. As for the legal consequences, that arise from the United Nations, these are none other than the obligation to pursue with vigor its permanent responsibility towards the question of Palestine, including its responsibility to ensure UNRWA continued effective functioning. The United Nations must continue to serve as a forum of internationalized cooperation for states working towards fulfilling their secondary obligation of bringing to an end the ongoing violation of Palestinian people's right to self-determination and the unlawful occupation of the Palestinian territory. Mr. President, Malaysia remains steadfast in our pursuit of a world where compassion and justice prevail. The principal judicial organs of the United Nations is us today. Do its part that in that noble pursuit. Malaysia sincerely hopes that it will agree to do so. Mr. President, this concludes my submission. I thank the court for its kind attention. Thank you very much.
I thank the delegation of Malaysia for its presentation. I invite the next participating delegation, Mauritius, to address the court and call upon His Excellency, Mr. Konjul, to take the floor. You have the floor, Excellency.
Mr. President, Madam Vice President, members of the court, it is an honor for me to address you on behalf of the Republic of Mauritius. Our presentation is in two parts. I will first make a general introductory statement. Professor Klein will then address you on the lessons learned from your recent HAGUE advisory opinion, in particular its relevance to the unlawful occupation of Palestinian territory and the legal consequences that follow. This matter comes before you at a time of grave human tragedy and immense suffering. As the court recognized in its recent order on provisional measures in the proceedings brought by South Africa, on 7th October 2023, Hamas and other armed groups carried out an attack in Israel, killing more than 1,200 people, injuring thousands and abducting approximately 240 persons, many of whom continue to be held captive. Thereafter, Israel launched a large-scale military operation in Gaza by land, air, and sea, which has resulted in massive civilian casualties, extensive destruction, and the displacement of an overwhelming majority of the civilian population in Gaza. As of date of the Provisional Measure Order of 26 January 2024, the court observed that 25,700 Palestinians had been killed, including thousands of children, over 63,000 injured, 360 homes destroyed or damaged, and approximately 1.7 million civilians displaced. These stark figures, Mr. President, will only have increased and will no doubt continue to increase. It is against this somber backdrop that the court is now tasked with providing guidance to the General Assembly on matters raised in the two questions before you. The United Nations General Assembly, in particular, has exercised special responsibility over Palestine since at least 1947. In 1970, the General Assembly recognized the importance of the universal realization of the right of peoples to self-determination and condemned those governments that deny the right of self-determination of peoples recognized as being entitled to it, especially of the peoples of Palestine. The right of the Palestinian peoples to self-determination has since been repeatedly reaffirmed by the General Assembly for more than 5 decades. This is not the first time that the court has been called upon to address the right of self-determination, and in particular in relation to the occupied Palestinian territory. In its 2004 Wall opinion, the court observed that the rights of the Palestinian people include the right to self-determination and this right was being severely impeded as a result of just one specific measure of the occupation, the construction of the wall to the east of the Green Line. The two questions now before the court are framed more widely. They require the court to consider the legal consequences flowing from the ongoing and increasingly severe impediments to the right of the Palestinian people to self-determination due to the prolonged occupation, settlement, and annexation of the Palestinian territory occupied since 1967. Mauritius considers that through its illegal occupation, Israel has denied and continues to deny the right of the Palestinian people to self-determination. At least two legal consequences inexorably flow from this. First, Israel must cease its occupation of Palestinian territory as rapidly as possible. Second, all states and the United Nations have a duty to ensure that Israel complies with its obligation to respect the right of self-determination of the Palestinian people and to end its unlawful occupation so that the Palestinian people may exercise their right to an independent and viable state of their own. Mr. President, members of the Court, the General Assembly's grave and long-standing concern and the necessity for the Court's guidance is underscored by the unprecedented participation in these proceedings. No less than 54 states and 3 international organizations have submitted written submissions, and most of whom will be addressing the Court in these hearings. No state or organization contests the Court's jurisdiction, and an overwhelming majority consider that there are no compelling reasons for the Court to decline to answer the General Assembly's questions. Mr. President, members of the Court, as you will be acutely aware, the last advisory opinion rendered by the Court concerned the decolonization of Mauritius, and in particular, the legal consequences of the separation of the Chagos Archipelago from Mauritius in 1965. From the time of its independence, more than 5 decades ago, the completion of the decolonization of Mauritius and its ability to exercise sovereignty and sovereign rights over the whole of its territory has been severely impeded as a result of the United Kingdom's unlawful occupation and administration of the Chagos Archipelago. The Court's advisory opinion delivered on 25th February 2019 concluded that, I quote, as a result of the Chagos Archipelago's unlawful detachment and its incorporation into a new colony, the process of decolonization of Mauritius was not lawfully completed when Mauritius acceded to independence in 1968. As to the legal consequences, the Court determined that the United Kingdom's continued administration of the Chagos Archipelago constitutes a wrongful act entailing the international responsibility of that state, and that the United Kingdom is under an obligation to bring an end to its administration of the Chagos Archipelago as rapidly as possible. Mr. President, the Court's 2019 advisory opinion made a significant, immediate, and irreversible impact. Less than 3 months later, on 22 May 2019, the General Assembly, by an overwhelming majority, adopted Resolution 73/295, welcoming and affirming the findings of the Court and demanding compliance with them. Less than 2 years later, on 28 January 2021, a special chamber of the International Tribunal for the Law of the Sea, in the proceedings on maritime delimitation between Mauritius and Maldives, affirmed that judicial determinations made by the Court in an advisory opinion carry no less weight and authority than those in judgments because they are made with the same rigor and scrutiny by the principal judicial organ of the United Nations with competence in matters of international law. Accordingly, the Special Chamber held that the Court's 2019 advisory opinion has legal effect, and it duly gave effect to the Court's determination that the Chagos Archipelago forms an integral part of the territory of Mauritius. Thereafter, in November 22, Mauritius and the United Kingdom decided to begin negotiations on the exercise of sovereignty over the Chagos Archipelago. While these negotiations are still ongoing, Mauritius remains confident that they will conclude successfully and that the United Kingdom will, as a result, bring itself into compliance with its international obligations, as elucidated by the Court in its advisory opinion. Similarly, Mr. President, Mauritius is confident that your advisory opinion in this case can likewise make a significant, immediate, and irreversible impact with respect to the right of the Palestinian people to self-determination. To those who suggest that the issuance of an advisory opinion might somehow prejudice the prospects of a negotiation, Mauritius underscores that, to the contrary, the Court's clarification of the legal rights and obligations of the parties facilitates rather than obstructs a good faith negotiation. Professor Klein will have more to say about this. We have utmost faith that the Court, as the principal judicial organ of the United Nations and guardian of international rules-based order, will carry out its judicial function without fear or favor. Mr. President, distinguished members of the Court, let me conclude by reiterating that Mauritius has consistently supported the two-state solution in view of its potential to bring lasting peace and stability to the Middle East region. Indeed, it is the only solution that could bring lasting peace. We believe that the Palestinians must be able to live in freedom and in their own state. We also firmly believe that Palestine possesses all the necessary attributes to be recognized as a state. Mauritius has indeed already recognized it as such. Thank you, Mr. President. May I now request you to kindly invite Professor Klein to the podium. Thank you.
I thank His Excellency Mr. Konjoul. J'invite maintenant le professeur Pierre Klein à la barre. Vous avez la parole.
Merci, Monsieur le Président. Monsieur le Président, Mesdames et Messieurs les membres de la Cour, c'est un honneur pour moi de prendre la parole devant vous aujourd'hui au nom de la République de Maurice. Comme vient de le dire l'ambassadeur Konjoul, les questions qui vous ont été soumises par l'Assemblée générale possèdent une profonde résonance pour Maurice. Elles présentent des liens étroits avec l'affaire des Chagos. Les mêmes questions fondamentales sont en cause dans les deux cas. Ils se caractérisent l'un et l'autre par des occupations prolongées de territoires en violation du droit des peuples à disposer d'eux-mêmes. Je voudrais dès lors détailler avec vous trois parallèles qui peuvent être opérés entre la présente procédure et l'affaire des Chagos. Dans un premier temps, je m'attarderai sur la question des limites à l'exercice par la Cour de sa compétence consultative, limites qui seraient, selon certains, susceptibles de résulter de l'existence d'un processus de négociation entre Israël et la Palestine. Je traiterai brièvement ensuite du fait que nous sommes confrontés ici à une occupation prolongée et de la confusion opérée par certains participants à la procédure entre les champs d'application respectifs du jus in bello et du jus contra bellum. Enfin, je terminerai par une rapide évocation des conséquences juridiques de l'occupation et plus particulièrement du devoir d'Israël d'y mettre fin dans les plus brefs délais. Monsieur le Président, Mesdames et messieurs les juges, certains des participants à la présente procédure estiment que la Cour devrait soit s'abstenir complètement de répondre à la demande d'avis, soit y donner une réponse limitée. Cette réserve serait justifiée, d'après eux, par la nécessité de porter atteinte aux négociations entre Israël et la Palestine ou de priver celles-ci de leur effet. Selon ce point de vue, l'avis que la Cour pourrait rendre en réponse aux questions qui lui sont adressées risquerait de délégitimer le cadre juridique établi pour régir le conflit, de même que toute perspective de négociation future entre Israéliens et Palestiniens. Monsieur le Président, la République de Maurice n'entend nullement remettre en cause le fait que les négociations que les parties au conflit israélo-palestinien se sont engagées à mener constituent la seule voie viable vers la paix. Ce processus est l'unique moyen d'arriver à la réalisation de la solution à deux États, un objectif auquel la République de Maurice reste profondément attachée, comme vient de le rappeler l'ambassadeur Kounjoul. Ce sur quoi Maurice souhaite plutôt attirer votre attention aujourd'hui, c'est le fait qu'un processus judiciaire comme celui-ci et des négociations ne sont en rien incompatibles, bien au contraire. L'expérience récente de Maurice dans le dossier de l'archipel des Chagos le montre avec éclat. Il n'est sans doute guère besoin de vous rappeler que ce dossier a fait l'objet d'un blocage complet dans les relations entre Maurice et le Royaume-Uni pendant des dizaines d'années. Mais en moins d'un an, entre novembre 2022 et septembre 2023, la situation de l'archipel des Chagos a donné lieu à pas moins de 6 rondes de négociations entre les deux États. Était-ce parce que les deux parties avaient soudainement été touchées par la grâce? Certainement pas, ou en tout cas, pas seulement. Ce qui s'est plutôt avéré déterminant, c'est évidemment l'avis consultatif que vous avez rendu en février 2019, ainsi que les suites réservées à cet avis, en particulier par le Tribunal international du droit de la mer, auquel l'ambassadeur Kounjoul vient de faire référence. En concluant que le processus de décolonisation de Maurice n'avait pas été mené à bien, la Cour a clarifié la situation juridique existant entre les parties. L'avis de 2019 et ses conséquences ont manifestement joué un rôle majeur pour convaincre les autorités britanniques de s'engager enfin dans la voie des négociations sur l'exercice de la souveraineté sur l'archipel des Chagos. Et il est particulièrement intéressant de relever que quand le ministre des Affaires étrangères britannique évoque ces négociations, il le fait en observant qu'elles prennent en compte les décisions judiciaires internationales récentes et qu'elles sont menées en vue d'aboutir, je le cite, à un accord fondé sur le droit international. Fin de citation. L'Assemblée générale ne demande rien d'autre aujourd'hui. Elle n'entend manifestement nullement faire obstacle à des négociations futures. Mais elle est soucieuse de s'assurer que tout processus de cet ordre soit clairement encadré par le droit, en veillant à ce que la situation juridique des parties soit ici aussi clarifiée. Comme le relevait l'un des membres de la Cour dans le contexte de l'affaire du mur, je cite, « Le respect d'obligations internationales, y compris d'obligations erga omnes, ne peut être subordonné à des négociations. » Fin de citation. Ce constat est certainement tout aussi vrai aujourd'hui qu'il y a 20 ans. La Cour, en répondant à la présente demande d'avis dans tous ses aspects, ne fera donc que baliser le cadre juridique dans lequel des négociations pourront intervenir. Mais ce cadre juridique est essentiel
puisqu'il permettra d'établir quels sont les objets de négociation qui sont acceptables ou non. Permettez-moi d'ajouter un dernier mot sur la question du pouvoir discrétionnaire. Selon certains participants à la présente procédure, la Cour, si elle répondait à l'intégralité des questions qui lui sont adressées, risquerait de contourner l'exigence cardinale du consentement au règlement juridictionnel des différends. Il en serait ainsi dès lors qu'elle serait amenée, par certains aspects de ces questions, à se prononcer sur le statut des territoires qui sont au cœur du contentieux israélo-palestinien, voire sur les frontières des territoires en cause. Le même argument avait été soulevé dans l'affaire des Chagos. Selon certains, il se serait agi d'un contentieux territorial bilatéral dans lequel la Cour n'aurait eu aucun titre à intervenir dans le cadre d'une procédure consultative. La Cour a très clairement repoussé cet argument dans l'avis de 2019. Elle a relevé que, je cite, « l'Assemblée générale n'a pas sollicité son avis pour régler un différend territorial entre deux États ». Fin de citation. L'objet de la requête de l'Assemblée générale était plutôt, toujours selon la Cour, d'obtenir l'assistance de la Cour pour que celle-ci la guide dans l'exercice de ses fonctions relatives à la décolonisation de Maurice. Fin de citation. La situation n'est pas différente aujourd'hui. Vous n'êtes aucunement appelé à trancher un différend territorial et encore moins à vous prononcer sur des questions de tracé frontalier. L'Assemblée générale ne cherche ici aussi qu'à recevoir votre assistance pour la guider dans l'exercice de ses fonctions relatives à la réalisation par le peuple palestinien de son droit à l'autodétermination. Il n'existe donc aucune raison pour la Cour de décliner l'exercice de sa compétence à l'égard de tout ou partie des questions qui lui sont soumises. Si l'on se tourne maintenant vers les questions de fond, il existe un autre parallèle marquant entre la situation de l'archipel des Chagos et celle des territoires palestiniens. Dans l'un et l'autre cas, ces territoires font l'objet d'une occupation de longue durée. Cette spécificité a suscité des débats dans le cadre de la présente procédure. Certains des États qui y participent ont à cet égard défendu l'idée selon laquelle le statut juridique de l'occupant résulte du seul fait de l'occupation sans que ce statut soit affecté par le caractère prolongé ou non de l'occupation. Il faudrait dès lors, selon cette approche, envisager la question de la licéité des actes de l'occupant sous le seul angle du droit des conflits armés. Par contre, la Cour ne pourrait se prononcer sur la question de savoir si l'occupation israélienne elle-même est illicite, car un tel constat serait dépourvu de fondement en droit international. Je pense que nous aurons été nombreux cette semaine à trouver cet argument surprenant. Il procède d'une confusion complète entre les règles du ius in bello et celles du ius contra bellum. Oui, les droits et devoirs de l'occupant à l'égard des populations des territoires occupés sont définis par les règles du droit international humanitaire. Mais cela justifie-t-il pour autant, ipso facto, la présence même de l'occupant sur le territoire en cause, présence à l'égard de laquelle le droit international serait en quelque sorte neutre, à en croire l'argument que je viens d'évoquer? Clairement non, car cette question ressort d'un autre corps de règles, non pas celle du ius in bello, mais bien celle du ius contra bellum, qui régissent la licéité du recours à la force dans l'ordre juridique international. Quand bien même les forces armées d'une puissance occupante maintiendraient un comportement en tout point conforme aux règles du droit de l'occupation, leur présence sur le territoire occupé serait elle-même illicite si elle résulte d'un recours à la force contraire au droit international ou d'un acte d'annexion. Le principe a été rappelé avec une grande clarté par plusieurs des participants à la présente procédure. Pour reprendre les termes de l'exposé écrit de la France, je cite, « Le statut de puissance occupante ne confère rigoureusement aucun titre justifiant une annexion ». Fin de citation. Et quant au passage du temps, s'il n'affecte pas le statut de puissance occupante au regard du droit des conflits armés, il ne peut non plus avoir pour effet de rendre licite une occupation de territoire contraire au droit international. La confusion entre les champs d'application respectifs du jus in bello et du jus contra bellum ne fait qu'obscurcir les termes du débat. Envisager la situation des territoires palestiniens occupés sous l'angle du seul jus in bello revient à ignorer complètement que cette situation est contraire à la fois au principe du droit des peuples à disposer d'eux-mêmes et aux règles fondamentales de l'ordre juridique international relatives au recours à la force. La République de Maurice n'éprouve aucun doute quant au fait que la Cour aura à cœur de réaffirmer la pertinence de ces principes fondamentaux. Ceci m'amène au dernier point de mon exposé, à savoir la question des conséquences de l'occupation prolongée des territoires palestiniens par Israël. À cet égard encore, les enseignements de l'avis sur l'archipel des Chagos sont on ne peut plus clairs. Selon l'avis de 2019, le maintien de l'administration de l'archipel des Chagos par le Royaume-Uni en violation du droit des peuples à disposer d'eux-mêmes constitue, je cite, un fait illicite à caractère continu. Dès lors, poursuit la Cour, le Royaume-Uni est tenu, dans les plus brefs délais, de mettre fin à son administration de l'archipel des Chagos, ce qui permettra à Maurice d'achever la décolonisation de son territoire dans le respect du droit des peuples à l'autodétermination. Fin de citation. Il en va indubitablement de même pour les territoires palestiniens occupés. Là aussi, l'occupation constitue un fait illicite à caractère continu, et là aussi, il doit être mis fin à l'administration de ces territoires par Israël dans les plus brefs délais, afin de permettre l'exercice par le peuple palestinien de son droit à l'autodétermination. Permettez-moi, Monsieur le Président, d'ajouter un dernier élément à ce sujet. Pas plus les accords qui ont pu être conclus entre Israël et la Palestine que les éventuelles négociations entre les parties ne sont de nature à rendre licite la présence israélienne dans les territoires occupés. La Cour a été confrontée à un cas de figure du même ordre dans l'affaire des activités armées sur le territoire du Congo. L'Ouganda cherchait à justifier la présence de ses troupes en territoire congolais en se référant à plusieurs accords conclus entre les belligérants visant entre autres à fixer, je cite, un cadre pour le retrait ordonné de toutes les forces étrangères afin de créer un environnement stable et sûr. Fin de citation. Mais la Cour a très clairement repoussé cet argument. Elle a relevé, et vous me pardonnerez la longueur de cette citation, mais elle me semble particulièrement pertinente dans le contexte qui nous occupe, que je cite donc « Les arrangements conclus à Lusaka en vue de s'acheminer vers un retrait des forces étrangères et de parvenir à terme à une paix qui garantisse la sécurité pour tous, entendaient prendre en compte les réalités du terrain et l'instabilité de la situation au niveau politique et sur le plan de la sécurité. Pour les parties à l'accord de Lusaka, les dispositions de ce traité établissaient donc un modus operandi. Elles indiquaient aux parties comment aller de l'avant. Elles ne visaient pas à donner une qualification juridique à la présence militaire ougandaise. Fin de citation. Et la Cour en conclut ultimement qu'aucun des éléments de ces accords, je cite, ne vise en général à établir que la présence des forces ougandaises sur le territoire de la RDC était licite. Fin de citation. La situation est exactement la même en ce qui nous concerne. Le processus de paix entre Israël et la Palestine, quels que soient ses aléas, vise bien à parvenir à terme à une paix qui garantisse la sécurité pour tous et à permettre aux parties d'aller de l'avant. Pour autant, aucun de ces éléments ne rend licite la présence israélienne dans les territoires palestiniens occupés. L'existence des accords de paix et d'un éventuel processus de négociation ne remet de ce fait nullement en cause l'obligation pour Israël de se retirer de ces territoires dans les meilleurs délais. Je vous remercie, Monsieur le Président, Mesdames et Messieurs les membres de la Cour, pour l'aimable attention que vous avez prêtée aux exposés oraux de la République de Maurice et je vous souhaite une très agréable soirée.
I thank the delegation of Mauritius for its presentation, which brings to a close this afternoon's hearing. The court will meet again tomorrow morning at 10 a.m. to hear Namibia, Norway, Oman, Pakistan, Indonesia, and Qatar. The sitting is adjourned.